chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care. With popcorn in hand and a comfy chair. And every twist, we're right there. Together like we're all in the witness chair. This is the Broken Baker, where the trials come alive. Where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night. So hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just flaming with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rise, we're just here for the case and the vibes. This is the Broken Baker, where the stories unfold. With a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin. Where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Baker, where the trials come alive. Yeah, we'll be here, trial after trial. Yeah.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what, if any, you might be. And quite surprisingly, we are already at closing arguments in the Lawrence Dority case. A case we found yesterday that started yesterday at 9:30 and where the defense rested at 3 o'clock. A case where we don't have to argue if he did it, because we know he did it. But we have to argue if it was justified self-defense. The state claims second-degree unaliving with the lesser included, and the defense claims, no, he was so afraid of Mr. Payne that he had to go into his house, come out again, and in protection of himself or others had to pew-pew. Sadly, he tried to wing him, but it went through and through into the chest cavity, and Mr. Payne passed away. I was very surprised of the level of evidence presented from both sides. I really thought that the defense lawyer would be good because he had a good opening. I should have reflected on it when he stopped his speech, went back and just started reading off his PC to figure out what he needed to say. But the prosecution didn't do much, and the defense just put the defendant on the stand, and direct was 25 minutes, and he came off as a massive douche canoe, as they call it in French. Hey, Robin G. and Helen from Holland. The fastest murder trial on earth. Even the guy who stood up and said, "I'm sorry, I did it," took 3 days. Oh God, they broke the usernames again. They absolutely did for some. Well, Felarowski, not. I don't know. I can't do anything. I saw it. I was watching, I think, Ethan went Skyver the other day, and it absolutely I don't know why YouTube always tries to fix problems by making it's the same. They'll change the algorithm. So before it was how much you people was willing to just come by and see that counted. Now they really want you to interact with the stream. So the more you sit and chat about Dirty Sand in chat, apparently that is what would get people notified about my stream right now. Back in the day, you could put in 3 hashtags, so people who were looking for the Lawrence Dority case or the Mr. Payne unaliving case would, oh, they're looking for that. The hashtag would tell you. No. Now it's you'll have to whistle Dixie and try and squeeze a piece of coal to a diamond. You gotta love being a YouTuber. The only thing that's certain is you'll never know what you're doing right, doing wrong. And that's why you'll probably see a lot of us trying to do a lot of stuff a little bit differently the next couple of days to try and figure out what the hell is going on. Because I lost around 100 viewers per stream. No, I can understand. Yes, the content isn't that good, but you can also see the videos I put up. Some have 20,000 views, others have 2. I don't know. I don't care. I have you here, and just like anywhere else, you don't want to hear about the trouble. Nobody knows the trouble I see. Nobody knows but Jemima. And YouTube is just stupid. Peasant. What peasant? Am I a weirdo for playing with Lego? It depends on in which way you play with it. And every letter is a capitalized letter because it's an abbreviation of Lie God, not a name. But you're not a weirdo because you play with Lego. There's so many other reasons. It's gonna be permanent. It's YouTube thinking they are fighting harassment. Oh, good. YouTube needs to capitalize on the TikTok algorithm. TikTok literally reads my mind, and I only get videos I'm interested in. On YouTube, I have to do a lot of digging to get content I enjoy. Well, it also is a very dangerous algorithm they have on TikTok because they'll only feed you what you like. YouTube kind of does the same. Then all of a sudden, you'll get some random Indian woman sleeping. But TikTok has one thing in mind. They want you to be addicted to TikTok. So if you like, I don't know, cake baking, they will only force feed you cake baking all day long, make you miss all the other content that you potentially could find, because their job is to keep you addicted, keep you watching, because that's where the money is for the companies. Hey, Plushie. You're lurking every day. I usually don't interact, just enjoy it. Well, we are glad if you're just lurking, and if you find something interesting or you have a question, please interact. I know some people get annoyed that I talk, but I like to keep people informed if they have questions. But please always interact if you need something asked. Maybe you weren't here yesterday and you want a recap, and I can go into more of it. Because why else watch it on a channel where there's a little person sitting next to the trial? We are here to keep you informed. If you have to go to the doctors or you have to take the dog out, then this little person in the corner can give you an update when you come back. And I know some people are saying, well, we're going to be so far behind. We never stop more than 10 minutes after. We are having fun. I guess Alfonso with a PH doesn't listen as much for marketing purposes, only on YouTube. I need more spaces and less numbers, YouTube. It makes it harder to socialize, yet YouTube claims it is to making chatting better because apparently we can't harass others now. I don't know if any of my European friends have had that where they want you to confirm your age on Twitter. That's because America has had their new England has had their new, you must be this old to watch content. And because they're idiots, they rolled it out so it hits everywhere in Europe. It's just dumb. And I have a really no, but it's fine, Annie. I don't say you have to engage or anything, or don't. I'm just glad you're here. And hey, tell your neighbors about me. And when they look at you like you have the plague and say, "Are you watching a Danish guy talking about court cases?" Maybe I'm going to call the police on you. Just run. But you can never satisfy the YouTube gods. You'll have good months, bad months, and hopefully we all end up some happy place. I did nothing. I did nothing. Yeah, there is. Well, it's not a spot on the booby light. It's see, it has this little knob on the side, and it's the same. It's just the angle that's different. But Nobby, the boob light, is hanging out, taking care of business in Caliphas. They're supposed to go live. Oh yeah. Oh, camera start. I like the judge. I didn't like he didn't catch that the defendant was using his phones yesterday, but I think he seemed okay with the rulings he have. Hey, Henrik, welcome. You have a great Dane? Well, all Danes are great. It's in the name. It's just something. It's because YouTube is fixing something or trying to do something, and they're going to take it back in 5 days. If you all go to TwitSwat and say, this is just stupid, because I know my good friend Sue by her nickname, Sue Love Summertime. I don't know who that is. So if you go in and just tag YouTube in that, that's the stupidest thing. I can write support in YouTube and complain and say, well, I'm having 70 people watching me right now. They are all complaining. They will do, because I need to be at least 200, 300,000 subscribers and maybe 10,000, 5,000, 10,000 viewers before they would even listen to me. But if you go on the TwitSwat and complain, there's a high likelihood that if they get 1,000 complaints there, it'll change back real fast. Isn't that wonderful that you have to go off platform to complain about the platform, to fix the platform on platform? It's so dumb. What's happening? Yeah, you're not Swayshire heavy these days. Well, my email is is the one I use for everything with my. So I don't know, but imagine how stupid it'll be when, hey, today I am having ML Super Lawyer New Jersey on, and we will be joined by YCT, Indie Addict, Desperate, Give Me Love, Plevin, and talk about his new book while me and Melanie laugh. Because why can I keep my brand name, but it's so dumb. It's just dumb. Yeah, but Helen Jenninson, without the 6176. But it's, well, I call you Helen from Holland anyway. Yeah, but that doesn't change anything, because if your name is Matt Smith, you can still call people a douche canoe. And I don't feel we have much of harassment going on. I know some people might not like the chat because we are a little more frisky sometimes. I know some people might love the chat because we are a little more frisky sometimes. And some people are just here to listen to the court and not engage in chat. But I think I've blocked 20 people, and most of them were for calling me stupid things or just being dumb in chat. Because as a creator, I don't want people harassing people in chat. That makes a bad environment, and I'm trying to kind of grow my channel. So of course I will do everything I can to try and keep harassment off my platform. So I just don't get this. I can get on a lolcow stream that people might sit and call each other fat or something, but on a court stream, it just don't make sense. It makes no sense, the argument that if I know your email address that you have signed up with that doesn't have to be your name, you will not say, hey, Baker, you're fat. It's dumb. Yes, I am stupido. Well, 69 is always 69. So, a little background about the victim, Mr. Payne. He was a gentle giant. His mother raised him with help of his grandmother. His mother actually passed away in front of him. In his arms, he had a fatal asthma attack. Oh, how sad.
Right, and then everything else.
Oh, and he had a small kid as well.
Trial in front of Adams, or a case that's already closed. All right, so we're done with the docket for the morning.
AP was just 13 years when she passed away. Oh, yeah. Oh, is Ozzy getting buried today? Those Baby Baker is a little fussy when he's about to. They are running on a 3-hour schedule with him being awake for 3 hours and then he's put down to sleep. And he didn't want to. He was a little fussy the day I have to bring them home because we were trying to drag it out so he could sleep on the way home. And then I put on Crazy Train. He was just like, oh, what's that music? And so thank you, Ozzy, for saving that day. Hey, 80s. So if I said I was grabbing your butt in my head, would I be in trouble? It depends if I like it. No, I don't care much about oh, she looks weird. Why is she so happy? It's a murder trial. The things you can get in trouble for is it's especially calling me a misogynist. That's the word I'm looking for. I really get annoyed at that. I have the two most perfect females I have made in the world, and I don't see them as lesser than anyone. I actually see them as better than anyone. So whenever someone is getting into that territory, they'll normally get a block if they keep doing it, or do the race baiting where it's just because you're white, you don't know how trouble is. You don't know me. You don't know I grew up in a poor-ass family with 4 kids, and my mom's working 2 jobs, and my dad had to take care of us a lot of the time because my mom had to work. So please don't do all of that. That can get you blocked. But if you're saying Zach looks like the fishy kiss or that Sue is way too mean.
Counsel on behalf of
That's
Mr.
okay.
Dority.
Right on. Mr. Dority is also present. All of our jurors are back. I have handed out.
This is Mr. Payne, who was a former NBA player, not highly famous, but he had been on a few teams, had a few years in the league. Come over to this guy's house because, and this is going to be a little convoluted. This guy's girlfriend, this guy is Lawrence Dority. He had been out drinking something, maybe, and him and his girlfriend had gotten into an argument. His girlfriend then texted Mr. Payne's girlfriend if she could come over She then texts Mr. Payne that she's going over, and he's saying, nope, you're not going over alone. We don't know what can happen. They then arrive outside of this man's house. At the same time, he arrives, and Mr. Payne was there before Mr. Payne's girlfriend. And this guy, his dad, his son, and his girlfriend arrives. Arguments, blah, blah, blah. This guy runs into the house, grabs a remote hole puncher, claims he wants to clip him in the arm because he's afraid of him and just want to scare him off by clipping him in the arm. Sadly, it goes into the chest cavity and he passes away. He admits he did it. He claims self-defense. Yesterday, we had about 5 hours. Opening statements. The state rested at around 2 o'clock. The defense only put him on the stand. The direct on the defense was maybe 25 minutes. So they rested both sides yesterday. We're going straight into closing arguments and verdict watch today.
Copies of the jury instructions to all parties. There's copies for the jurors, and I do have the verdict forms up here that we all discussed yesterday.
Find the microphone.
Any other matters or issues that I need to discuss or take care of from the state?
No, Judge, just for as far as jury instructions, do you read the majority of the instructions before closing or after? I think judges flip them differently.
Well, I like
don't have a
it.
preference.
I typically prefer the majority of them to be read before, but again, that's obviously.
No, I was very surprised.
I don't have a typical preference. If you want me to do it, I'll do it. If you don't want me to do it, I won't do it. If you want me to do it, tell me where you want me to stop that.
Lift him up to his.
I have no preference either way. I have no preference either way.
I would suggest potentially going up until rules for deliberation, stopping there, and then closing arguments, and then going to the rest of the way from rules for deliberation. It's on page 12 of your instructions.
And he was drafted at number 15. That's a pretty good draft number, but sadly, it didn't really transition into him having a great NBA career. Am I correct in believing that the girlfriend said that he had been out playing Euroball for 4 months, or been abroad, maybe Japan? I don't know where he went. But as I understood her, he had been away for 3-4 months playing basketball somewhere else. We have a basketball team in my town, and we can get like second, third rate college players when they can't get into the NBA. They'll come over here and play for a couple of years.
Sure.
Okay, so you'll read up through the rules for deliberation, stop there, have you do your closings, and then read those remaining 3 or 4 instructions and send them out.
That would be the state's preference. Everybody else is in agreement.
Any objections?
No objection, Your Honor.
Okay, I'll do that. Anything else from the state that I need to address?
Nothing further from the state.
Anything from the defense? All right, we discussed yesterday, each side's agreed to do their closings in 45 minutes or less per side.
Yes, Your Honor.
Yes, Your Honor.
45
All right,
or
we do have all the
less.
jurors back, so let's go ahead and bring them in.
I can't see them going for 10 minutes.
Ladies and gentlemen, welcome back. I trust that you all complied with the instructions. You didn't do any investigation or any research on your own or have anybody have any contact with you reference this case over the evening, correct?
Yeah, can we get a petition to Florida that if they have an unaliving case, they must have better ring camera?
When we spoke yesterday, both the state and the defense had rested their cases. The court released you all early so that we could finish the jury instructions and the verdict forms. We have completed that. You do have a copy of them. You're free to take those back into the jury room with you. What we're going to do is I'm going to split up the way that I read the jury instructions a little bit. I'm going to read the majority of the jury instructions through about the top of page 13 to you now. I am required to read the jury instructions to you. I give you a copy so that you can take them into the jury room with you, but I have to read them out loud to you. The reason I'm reading the first about 12 pages to you is so that you hear from me what the law is that applies to the case before the lawyers argue to you what the law is and what the facts are that may apply to that law. So you'll have heard it from me first, so you know what the law is as they make their arguments. Then they will do their closing arguments, and then I will pick up on page 13 with the last few instructions before I send you out and go over the verdict form with you to let you deliberate, okay? All right, so with that said, we'll go ahead and start with the reading a portion of the jury instructions before they do their closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Lawrence Alexander Dority, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. In this case, Lawrence Alexander Dority is accused of second-degree murder with a firearm. Murder in the second degree includes the lesser crime of manslaughter, which is also unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Adreian Payne was killed by Lawrence Alexander Dority, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the
He just started reading, so now we're going to learn what is self-defense in the state of Florida.
heat of passion upon any sudden and adequate provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lawrence Alexander Dority may be found guilty of second-degree murder or any lesser included crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Adreian Payne is dead. 2, the death was caused by the criminal act of Lawrence Alexander Dority. 3, there was an unlawful killing of Adreian Payne by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another person and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another.
Apparently, it's so you won't harass each other online, because that's a big old problem on YouTube. I have said to YouTube, just remove Zach and the problem will be gone. He is a serial harasser. But I can't do anything about it. I don't get an email from YouTube about it. Fedorowski probably knows more about it than I do.
And 2 is done from ill will, hatred, spite, or an evil intent. And 3 is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Lawrence Alexander Dority did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Lawrence Alexander Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Adreian Payne. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of second-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Adreian Payne, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive.
They can't tell you what reasonable doubt is, but they're just going to tell you what a firearm is, because
To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. To prove the crime of manslaughter, a lesser included offense of count 1, the state must prove the following two elements beyond a reasonable doubt. 1, Adreian Payne is dead. 2, Lawrence Alexander Dority intentionally committed an act or acts that caused the death of Adreian Payne. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Lawrence Alexander Dority committed manslaughter, and you also find beyond a reasonable doubt during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm, again, is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Lawrence Alexander Dority constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Lawrence Alexander Dority does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force is as follows. Lawrence Alexander Dority was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself, or the imminent commission of a forcible felony, aggravated assault against himself. The definition of aggravated assault is as follows. An aggravated assault is an assault with a deadly weapon without intent to kill. An assault is an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent. Lawrence Alexander Dority had no duty to retreat before using or threatening to use deadly force. In deciding whether Lawrence Alexander Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lawrence Alexander Dority used force or threat of force to initially provoke the use or threat of use of force against himself, unless 1, the force or threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using or threatening to use deadly force on the victim. Or 2, in good faith, Lawrence Alexander Dority withdrew from physical contact with Adreian D'Angelo Payne and clearly indicated to Adreian D'Angelo Payne that he wanted to withdraw and stop the use or threatened use of deadly force, but Adreian D'Angelo Payne continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lawrence Alexander Dority and Adreian D'Angelo Payne. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge
He had no duty to retreat, is what he said.
is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict of the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented.
I haven't kept
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply.
Oh, yeah, I saw someone didn't feel welcome yesterday. I feel you are always very welcoming to new people. I do warn new people of Zach, so maybe it was Zach again. But I feel you are very friendly and very welcoming, chat. Maybe they just didn't feel particularly welcome, and I blame Zach for that, or Sue. Zach or Sue. It's always one of those. I think you are always very nice, and you respect each other even when we disagree, because this is not a safe place for snowflakes. But I don't believe that new one. I just thought that I was kind of weirded out by reading it, that they didn't feel welcome, because I think I saw a few of you comment and say hi when they came into chat, but normally everyone kind of participates when people come in here, and now I can speed it up again because this is getting drony.
Apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer.
When you finish your stream, you will have X, then they will roughly cut 1/3 of it, and then you'll come back and they will give it back within 24 hours.
To talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions. At that point, I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken.
Did I miss someone saying this chat is mean? No, they just didn't feel super welcome yesterday, and it can happen. And I hope they'll give us another try, because even I find that most of you in chat are good people. The ones I mention as not good people a lot of the times, maybe, yeah. But again, people, I had another person getting mad and wanting me to put chyrons. I can't put chyrons on. I'm restreaming another product, and I don't have that ability in StreamYard. I haven't done it in 3 years, and all of a sudden they wanted me to put chyrons on. There's always someone who will have a bee in their bonnet, or they will have a day where they don't feel welcome. I love y'all, and I know you're doing the best to keep this a friendly, happy, smiling people place, like the REM song, which I hate. So let's not worry about that 1 or 2 person every day that has a little bee in the bonnet and just need to come back at another time and find out that Zach isn't here every day. And then let's go on to the closing arguments and hear why we find this guy guilty, not guilty.
The state wish to give their closing at this time?
Yes, Your Honor.
You may.
Thank you, Your Honor.
Put up a camera.
May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adreian Payne that night. He didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adreian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion, it would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground at CPR with another officer. Unfortunately, he was unsuccessful. Now you heard as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. You got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case's girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa, that she then spoke with her boyfriend, Adreian, who said he was also en route there as backup to her. Now, you heard that she got there just after Adreian had arrived and saw the defendant sort of walking away after apparently having words with Adreian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." Then she told you he didn't listen. He does take the gun out. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told while they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adreian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video and you heard from her that she ran down to a neighbor's house. She tried to get help. And then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the position, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta, and you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case, and that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence, and it goes through the factors that you look at.
Just so we can talk about something other than the stupid name change. I said, YouTube, the stupid name change thing that turns every stream into an argument why you did that. Could you drop it? It won't stop anything you claim, and it just pisses off your users. See, don't tell you I don't do anything. This is what you get if you subscribe to the membership. I'll do a tweet yelling at someone now and again.
When weighing the credibility of the witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony, as he said certain things with his counsel, but then when I questioned him about it, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Tara Walker, and that testimony of Tara Walker is corroborated by the video. And
the rollout will happen at any chance. I saw it in Ethan Van Sciver's, and I think on records this morning he also had it. So yeah.
Audio from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door in his direct testimony, he said he had never been Mirandized, but then obviously he was impeached on the transcript of him being read Miranda. He said that he didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adreian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said. But after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well, and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared, even if it wasn't justified, or maybe whatever the situation is, he's not that old. I don't want him to go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just two elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just two elements. There's three elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that Adreian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Dority intentionally committed an act or acts that caused the death of Adreian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the two things that you can consider for manslaughter for elements are that Adreian Payne is dead and that the defendant committed an intentional act that caused the death of Adreian Payne. We've proven manslaughter. We've met those elements. But you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail.
I can't with this prosecutor.
If you can't read it exactly on the screen, like I said, you put it in your packets. It is on page 3 of your packets. But so there's the same. The first element is the same, that Adreian Payne is dead, and that the death was caused by the criminal act of Lawrence Dority. That criminal act is taking his firearm and shooting him while he's sitting in or by his car. The third element is the difference, that there was an unlawful killing of Adreian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it at him, you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something that you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E. But each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And again, I want to point out too, all of these are ands. So you have to find all of them for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house, a reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a
Teresa, the state never put on any kind of case, just that, the bullet came from the gun that we agreed it came from. The defense put the defendant on the stand, I think 25 minutes, where he was caught in 2 lies on cross. Not worth going back looking at, other than to watch my beautiful face.
scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but.
The DA doesn't need to prove anything. He admitted he did it. The DA just have to say that it's not self-defense.
So the defendant in this case took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. Second from the bottom on this page, I don't know on your packet, but it starts with in deciding. So the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence, but the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense. And it's...
Well, there's no no way that you can force a man to leave a public area. And if he's sitting in his car with his window rolled up, it's hard to say that he was a threat to anyone.
Certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right, defense.
Your Honor, maybe approach more briefly.
Come on.
He took 23 minutes roughly. So he has 20 minutes left to come up. I don't like this prosecutor. Him going up, just reading again what the judge already read to them, never ever. I was listening to Robert Barnes and Ricada this morning, and Ricada said one thing that he had been doing when he was in law school. He was working on a project with his professor where they wanted to implement storytelling in law school to make them better at presenting. And I really think this prosecutor could have used some lessons in how to tell a story, because just going up there and read it and say, yeah, well, he was the bad guy, doesn't really tickle my fancy. Hey, Tom Gillis. Oh, we're going to the sidebar. She's going to withdraw. Oh, we have a demonstrative.
Good morning, ladies and gentlemen. Good morning. I'm going to stay at the podium this morning. That I really want you guys to hear what I have to say. Let's forget all the antics, okay? You remember during jury selection, I said we was going to have a real conversation, right? Real conversation. And the state and I felt like you guys were the most suitable jurors after Adreian. Okay.
And this guy could use some public speaking lessons as well. I love his outfit. I have to say that. He seems timid. He shouldn't seem timid.
There's three sides to every story. I know you probably heard that before. One person's version of what happened.
No, Lawrence wasn't at his home. He was on a public road. You can't just claim public roads as your domicile. It's actually said in the. If you go back and listen to the jury instruction, there is a distinction of what is your home.
A person's version or perspective of what may have transpired. And then there's the truth, right? The truth, ladies and gentlemen, is you at this point. You determine what the truth, what the facts are in this case. You have the ability to give us justice here today. Okay? My opening statement, I explained to you all what you would hear in this case. And I submit to you that the defense kept its promise. Okay? We kept our promise in this case. This is a case about self-defense. This is a case about reasonable doubt. Now, the state has rested, defense has rested, and we both are asking you to use your God-given common sense. Consider all the reasonable inferences that comes from the facts that you heard and saw today and throughout the scope of this trial. Consider what you heard what you didn't hear, what you saw, what you didn't see. Use your common sense, okay? This case is not for the weak at heart.
And just before I'll let him talk, he's not a public defender, but he is the second or third lawyer that Lawrence have had.
He selected you guys hoping that you wouldn't just have sympathy one way or the other, you know, just unbiased, impartial citizens. This is your highest civic duty to sit on a jury. This is literally the highest mode of citizenship you can have. Sitting right now and in judgment to decide whether someone should be found guilty for a crime that they've been accused of, and falsely accused of at that. Okay? I thought about this last night when I was summing up the evidence in this case, and a huge question just jumped out in my mind. And I already had been thinking about it throughout the scope of representing Mr. Dority, but after the trial, when the state actually presented and showed their hand, you know what that question was? Where's the proof? Where's the proof? The state has a burden, a high burden, that they have to overcome. And I submit to you, the state has not met their burden. They did not. It's not your job to stack inference upon inference upon inference to come to a conclusion that Mr. Dority did not act in self-defense. If you have a question in your mind right now, an unanswered question, if you have an unanswered question in your mind about the facts of this case, if something's not sitting right with you, if something's troubling you, if it's something that you would have wanted to see or needed to see to come to a conclusion and you can't make sense of why you didn't get that, why you didn't hear that, that's reasonable doubt.
Objection, misstatement of the law.
Sustained. I've given you what the instruction is on reasonable doubt. You have it in writing. You should consider that, not what the lawyers argue. Understood?
I'll go directly to the jury. The court has already given to you. And again, you guys use your common sense, okay? And I'll say this a little differently. Mr. Dority is not required to present any evidence or prove anything at all, number one, right? That's not his job. He could have sat at that table, played tic-tac-toe. He could have been texting if the court would allow. Of course, decorum doesn't allow that, but you get what I'm saying.
Well, he did do that on the stand yesterday.
Yeah. He didn't have to do anything, okay? Proof beyond a reasonable doubt does not mean proof beyond all doubt. Of course not, right? Reasonable doubt is not merely a possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. If you have an abiding conviction of guilt. On the other hand, this is what I want you to really pay attention to. If after carefully considering, comparing, and weighing all the evidence there is not an abiding conviction of guilt, or if you having a conviction is one that's not stable, one that wavers, vacillates, then the charge is not proved beyond a reasonable doubt. And guess what? You must find him not guilty.
It was
Not me.
my
You
dance.
must do it. So nobody in this courtroom other than Mr. Dority, I don't know if Ms. Walker's in here, at some point, no one, neither of you, the court, myself, the state, was at 2529 Egret Shores Drive on May 9th, 2022. Right? Everything we say is like our best efforts to try to advise you of what happened that morning around 1:30 a.m. It's a very serious case, ladies and gentlemen. And it's a sad fact that, unfortunately, it's a large sum of people who are murdered every year. And we ask you not to just base this case off that type of sympathy that someone lost his life. We acknowledge this is a very sensitive, sad situation. Both families have been impacted. So out of respect for both families, this is a tragedy. But Mr. Dority didn't go looking for trouble. When tragedy happens, right, it becomes a duty of law enforcement to be competent, careful.
Because this is a self-defense case. A self-defense case is, yes, I did it, but I did it in defense of me or others. So he can say there's reasonable doubt if he was afraid of Mr. Payne. If he was afraid of Mr. Payne, according to the statute in Florida, and it's a reasonable fear, he is allowed to unalive him. So that's why there can be reasonable doubt. We are not in a murder case per se. We are in a self-defense case. And if they don't believe it's self-defense, well, then he's convicted of murder by his own admission.
Timely, diligent in the performance of those duties, especially when investigating homicides and violent felonies, and doing it without a bias, without a rush to judgment. So let's talk a bit about what the evidence did show, right? The evidence revealed that neither Mr. Lawrence Dority or Lawrence Dority's fiancée, Tatiana Mesa, invited Mr. Payne over. You didn't hear from Tatiana. You didn't hear that from her mouth, that she invited Tara over. Where's the text message? You remember that? Tara Walker wants you to believe she was texted by Miss Tatiana Mesa to come over. Did you see a text message? Where's the proof? The evidence showed that even Miss Tara Walker advised her boyfriend, Mr. Payne, not to go over to Mr. Dority's house. She admitted to that fact. But why? Why was he there? Why was she there? The crime scene was contaminated. And I'm going to expound upon that a little bit later. That's very important. It's so very important to this case, fatal to the state's case. It's fatal to the state's case. There was evidence that was not properly secured and processed. Tara Walker's testimony is not credible. There's inconsistency in the state's case. There's lack of evidence in the state's case. And when you go through the jury instructions, that is a factor that tends to go towards reasonable doubt. When there's inconsistency in the evidence, lack of evidence, inability of witnesses to recall what happened, you know, Mr. Doherty's actions were justified under the circumstances of this case, ladies and gentlemen. Mr. Doherty was standing his ground. Let's talk a little bit more about what you heard over the course of the trial, though. Now, in the opening, the state conceded that Mr. Dority and Mr. Payne had brief words, right? So all of this badgering Mr. Dority on the stand about him allegedly telling a detective that he made no comment, that he just walked out the house and shot this man. Ladies and gentlemen, you heard it on the video that it was verbal. Not only that, Tara Walker, even though she didn't want to really say what happened, she said she pulls into the neighborhood, pulls up to the house, and sees her boyfriend standing outside the car, sees Lawrence Dority talking to him, and based on her words, they were communication was happening. Such a soft word, right? They was just communicating at 1:30 in the morning. Just communicating. That's not what happened. The state tried to create some sense of a factual inconsistency, knowing the fact of the matter is that the evidence revealed there was in fact a verbal altercation outside of Mr. Lawrence Doherty's home at 1:30 in the morning. And Mr. Payne's vehicle is outside of Mr. Doherty's house. Feel free to ask for a read back of the opening statement if you don't recall that.
Objection. The opening statement is not evidence.
Sustained.
Exactly.
The state made no mention of Mr. Payne's girlfriend being present during the initial altercation either, because she wasn't. Mr. Payne arrived before her. They didn't meet together. You remember? She was saying that at some point she decided to text him and say, hey, I'm headed over to Tatiana's house. I don't know, something's going on, something. And he took it upon himself, oh, I'm going to go over there too. I'll meet you there. No, don't go. No, I'm already on my way. I'm on the 408. I'm on my way. Don't even know where he stayed at. Driving around the neighborhood, cabins in the neighborhood, looking for my client's car. 1:30 in the morning.
No evidence was presented of that.
So at some point during the verbal altercation, Tara Walker arrives. Mr. Payne actually walks up to her car. And at some point she tells him to get back in the car and move his car up some more, closer to the house. But do you remember what Tara said? That when she first arrived, that the first person she talked to was Larry Dority, Mr. Lawrence Doherty's father. And what did Mr. Larry Dority say to her? Tara, get back. I'm about to go get my gun. Now, if it wasn't a threat that appeared imminent or of some sense of seriousness, that's consistent. Use your reasonable inferences. You're allowed to use reasonable inferences. So that's one fact that's admitted by the state's own witness. The state has proven the defense's case. When Tara Walker pulled up, Larry Dority told her to get back. I'm about to get my gun. She said, no, don't do that. That's my son's father. That's my boyfriend. Oh, I've never seen him before. That's a big fella. How big is he? Wait a minute, let me see. Medical expert Dr. Hansen said he was 80 inches.
What's going on? What is going on. I'm dumbfounded.
Mr. Dority, could you stand up for a second? With your permission, Your Honor, may I ask my client to stand up, please?
That's fine.
See, what Mr. Payne was doing, he was coming to try to pick a fight. He was trying to be intimidating. He wasn't coming to sing a Christmas carol outside his house at 1:30 in the morning. He wasn't delivering for Uber. He wasn't delivering for Amazon. He had no right to come to his house. Now, if you believe he has a right to be in the street, just parked outside, just waiting, lying in wait for someone with your car running, headlights on, just sitting in the car, and then when someone walks up thinking that you're someone you know, you hop out with a threatening gesture. Mr. Dority goes in the house. A reasonable person, you know what a reasonable person would do after having an argument outside of someone's home that you don't have a right to be at 1:30 in the morning? And when that person gets ready to go in the house, after you threaten the person and he goes in the house, by the time he comes back out, you should be gone. But guess what? He moved up a little bit closer. And guess what?
I'm just told.
Mr. Dority's son was still outside, who was 9 years old at the time, 8 or 9, give or take. His dad was 62 years old. There's inconsistency in the evidence, ladies and gentlemen. There's lack of evidence in this case. So let's talk about Deputy Garrett Morris. He was very forthcoming and candid, professional. He arrived at the scene. You can see this.
He's defending Lawrence Dority, and he's not doing a good job. I really liked his opening statements, and he has really disappointed me since.
Body camera. He rushed over, and basically he was administering life-saving measures to try to revive or try to just get some sense of keeping Mr. Payne viable till paramedics can arrive. You know, he arrived, he located Mr. Payne in the driver's seat at that time, one left foot out of the vehicle, right foot in the vehicle, you know, but he wasn't all in the car the whole time now. Only after this shot hit him and set him down, he went and got in the car. Because you remember, I was talking about Dr. Hansen. I don't want to jump around too much, but I'm going in the order of where the state called their witnesses. So just walk with me through this journey of justice real quick. Just walk with me for a second. Detective Garrett arrived, pulled Mr. Payne out of the car, and started trying to administer CPR. Okay. He did a brief search of Mr. Payne's fanny pack. He did not see any weapons in there, but he did not search the vehicle at all. Okay. That's pretty much all he did. After this, fire and rescue arrived, and then Deputy Garrett says he maintained the crime scene. Just himself, just Deputy Garrett maintained the crime scene. He testified that he put up crime scene tape. He held the area around the car until homicide and forensics units arrived. Now, he was equipped with body camera footage, remember? Did you see if he maintained the area on that?
Well, that's just racist against Floridians because most of them starts with Florida or Iowa or Massachusetts.
That body camera footage that you saw, where's the proof? Body camera's on. You on duty. You're working. See, the state is trying to cherry pick with you. They're picking to just try to show you some things, to try to spoon feed you. You ever had Thanksgiving dinner that was so nasty that you had to sprinkle a little sugar on it to make it taste good? That's what this tastes like. That's what this is.
What?
No. Don't let them force feed you. If it's nasty, it's nasty.
Just a quick question. I'm Danish. I'd never had a Thanksgiving dinner in my life. You eat turkey, yams, patatas, and cranberry sauce. I've eaten turkey in my life. My mom used to make it for Christmas. She made it dry as all hell, but I like the skin on it. I've never ever had, even with the dry turkey my mom made, I just put gravy on top of it. What part of the Thanksgiving dinner would you sprinkle sugar on to make it better? Top 5 things from Thanksgiving that gets better with sugar sprinkled on top of it, and we're not talking about the dessert because that has sugar in it.
All right, let's proceed. The state published the body-worn camera footage, and the footage did not reveal that he maintained his area around the car. In fact, there is no evidence that the area around the car was even secured or maintained free of contamination or free of manipulation. Also, Deputy Garrett candidly admitted that when he arrived on the scene, the passenger side door of that black Chevy sedan, that Malibu, was already open. Now, he initially testified that he believed Tara Walker was on the passenger side, but then he couldn't really say that because the door is already open by the time he arrived. All right? And again, he did not search the interior of the vehicle. And I ask you again, where's the proof, right? Somebody.
Because it's self-defense, Katrina. As self-defense, if it's a legal self-defense, you can plow all you want, as long as it's legal. You have to, you have asked this question 5 times already. A self-defense case is a murder case that you admit I did kill them, but I did it because it was a danger to me or others. And in Florida, if someone is a danger to you or others, you are allowed to take your cordless hole puncher and put some new breathing holes in them. So this has nothing to do with the murder. It has all to do with the reason for the murder.
To gain access to the passenger compartment of the vehicle. That door was completely open. Tara did say at some point in her testimony that she went on the driver's side. I'll get to her testimony in a second. I'm just going to keep going down chronologically. But you know what else jumped out? And I hope you guys asked to watch that video again. If you listen closely to
yes, but if it is a big enough threat, you can take your cordless hole puncher and just start punching holes.
Deputy Garrett's body camera footage, Tara Walker is heard in the background saying, "Why am I here? Why am I here?" You said you was here because you was invited. Seemed more like a setup or something. What's going on? You know, Tara has a motive to not be honest in this situation, because you know what this is? When Mr. Dority arrived home and he approaches the vehicle that he was familiar with at one point, believing it to be Tara Walker, but unknown to him, a 6'8", 247-pound man steps out and in a threatening manner steps over to him and say, "I'll smoke you. What you want to do?" That's an aggravated assault with a weapon. That's a felony, a forcible felony. And if Tara Walker invited him over to do that, that means she conspired. with Adreian Payne to commit a forcible felony of aggravated assault. Use reasonable inferences, ladies and gentlemen.
25 minutes.
So let's talk about Hannah Minor, the crime scene investigator. She, at the time of this incident, May 9th, 2022, she had only been employed as a crime scene investigator for 4 months. She had just started January 2022. So she's 4 months in on the job, relatively inexperienced. And it technically shows, because the role of a crime scene investigator is to respond to the crime scenes, document the crime scenes with photos, notes, sometimes measurements, document evidence, collect evidence, process that evidence, package that evidence, forward that evidence to its final location, whether it's in a laboratory or evidence unit, and write reports of their involvement in those cases. And of course, they work in conjunction with law enforcement and detectives. This is her exact testimony, right? It's from my notes, right? But she failed to document and process, collect that knife. She didn't dust for prints. She testified that it can be done, and case by case it can be done. She didn't try to get any touch DNA. She testified that she can do that. It's case by case. So in a case like this, a homicide, an allegation, if someone died, that's not something where you think that's important to dust. She agreed that it can be a weapon. It is a weapon. But Tara is saying she's just been driving around with a kitchen knife for 4 months. A mother is not driving around with a kitchen knife on the front passenger side floorboard in plain view for 4 months. That's not believable. What one would hope or think. So May 9th, she was on call, crime scene investigator. Their office is short-staffed. They only staff to midnight. So any calls that come in after midnight goes to the on-call crime scene investigator, where they take the call from home.
Thank you. She's like Texas 12. I hate these names. Kathy Souza, Rachel, Happy Hiker, Kathleen Kirkley, Victor Man, Beth Duggan, Taxi Jen, O'Curie, I don't know. Who knew 29? Who knew 28? Dennett, 1612. No, that wasn't a gift. She was already a member. And Dillinima 69, Giggity 91 was all gifted one of those wonderful 10 memberships. Thank you so much. She's like Texas 12. And all of you new members, you get the Super, and that's kind of all I do for my members because I'm a horrible, horrible grifter. I'm glad I can now speed this man up because he's way too slow. This is really bad. But I will give him that knife in the floorboard wasn't there because they had used it when they went out to dinner. That was an anti-theft device.
Minor, Miss Minor, investigator Minor.
Thank you so much.
She didn't get notified till 4 a.m. This incident, Mr. Dority arrived at 1:30 in the morning, right? Do you remember the testimony of Tara Walker when she said her brother arrived at 2 a.m.? Follow this for a second. 1:30 in the morning, he gets home. 2 in the morning, Tara Walker's brother arrives. 3 in the morning, Tara Walker's father arrives. 4 in the morning, crime scene investigators notified. And 5 in the morning, she arrives. 7 in the morning, Tara leaves with her car still at the scene. Crime scene investigator never took a picture of her car, never searched her car, didn't even know her car existed. Although Tara was alleged to have been at the scene at the time of this incident. Nobody even took identification from her brother. And what is her brother's name? Nobody knows. What kind of car he drive? Tara said a BMW. Crime scene contamination. You heard testimony from Mr. Dority that he seen her go in the car and run, and she didn't come back out until she was talking to law enforcement, till law enforcement arrived. But what time did law enforcement arrive? The only person you heard from was Deputy Garrett. Where was the other officers, if any? And what time did they get there? How could you secure a crime scene? Where's the proof? It's like It's akin to someone throwing rocks at a glass window, and when you come outside to confront them, they're hiding their hands. Where's the proof? This is serious. This is someone's life. The state wants you to believe that my client just comes out the house, guns blazing, just shooting at someone for no reason, in cold blood, without adequate provocation, without it being in fear, just willy-nilly. Use your common sense. That's not what happened. And it's not the defense's job to show you things that it's not even, it didn't happen. The video that the state showed you doesn't even show the actual it doesn't show any body, any person in any frame. All you hear, it's a video of audio. It's a video of audio. They didn't. How about this, if this don't convince you? When Mr. Dority testified in the defense rest, the state didn't even put on a rebuttal witness, no rebuttal evidence.
That's not an argument.
They haven't rebutted self-defense.
Nope. Well, maybe to some.
Their own case established
I don't
self-defense, arguably. And after hearing from Mr. Dority, who refuted that? Tara wasn't there when he first encountered Mr. Payne. Now, I imagine what may be troubling you guys is that there was actually no gun found in the car. But it's a reasonable explanation for that. You know why there was no gun found? Because the gun that he had was removed. Either by Tara, her brother, or somebody.
Objection, facts not in evidence.
That's a reasonable inference.
Overruled.
You're allowed to make reasonable inferences based on the facts. That's her job, to collect and document the knife. It was still in the car, not taking in evidence at all. You didn't even have a chance to see it today. I couldn't present it to you. It was not taken into evidence. That's not fair. The state can strike hard blows, but they can commit fouls now. Mr. Payne's girlfriend, her car was on the scene. It was never searched, no picture taken or anything. Investigator Minor agreed that she did not document the vehicle. She wouldn't know what was inside the vehicle because she didn't document the vehicle. And she agreed that part of her duties were to collect evidence, and she failed to document or collect evidence. This means this was an incomplete investigation, insufficient investigation. Marco Quintana, the neighbor, had that Google Nest camera. He didn't see what happened. The actual altercation didn't occur in video, but you just had the audio. He basically just provided them with audio. Not much value to the case at all, other than just at least allowing you to see that the actual argument did happen. You can hear that something happened outside, and then you hear the gunshot. Mind you, Mr. Dority only fired one shot. It's not like he unloaded a clip. He shot to repel the threat. He didn't shoot to kill. He didn't ask for what happened. Even in the state's opening, he says that Tara Walker speaks with her boyfriend and he decides to come over to the residence as backup. Backup? Backup for what? I hope that you guys, you have to base this case on the facts that you heard in court, not anything external. Not just, this is the case. The facts are the facts, and they didn't meet their burden. They didn't. Tara Walker says that Tatiana Mesa texted her and said, meet me at the house in 15 minutes. Did she meet you? Where was it? There was no meeting. It's not right, ladies and gentlemen. You are empowered with the ability to give us justice here today. Justice demands not guilty. His actions were justified. When you go through this jury instruction and look at the justifiable use of deadly force instruction, all those elements are met. It's like, think about this. The elements, you think about elements of any type of crime or any type of rule of law. Think about a peanut butter and jelly sandwich, right? You got peanut butter, jelly, and bread. If you're only presented with bread and peanut butter with no jelly, then guess what? It's not a peanut butter and jelly sandwich. It's missing a necessary element. This is a very simple case. Very simple. Getting back to some of the comments, Mr. Payne, instead of leaving, pulls his car up closer to the home and gets back out of the car. Mr. Dority again questions, why are you here? You need to leave. You can't really hear much of the conversation. Like, it's muffled. It did happen relatively quickly. It happened relatively quickly, And you can see in that video that my client's son was very, very close in the vicinity of this situation. And it was not until Mr. Payne reached in a threatening manner as if he can pull. It just goes back to Dr. Hansen, right? Let's talk about her for a second. She has 35 years of experience. 35 years since 1990. She did maybe 250 to 300 autopsies a year for 35 years. And she testified that the trajectory of the bullet wound that Mr. Payne was inflicted with pierced the tissue of his bicep. Mr. Femur twisted, it just pierced it, and then it went into his chest cavity. But it's consistent with this movement. Thumb down, arms raised. How is this not consistent with someone trying to aim a firearm at you if you're left-handed? The testimony is he was left-handed. You can absolutely aim a gun. I apologize if I'm aiming at you like this, but I really need you to see this. A gun can be aimed like this. This is consistent. And just because the gun wasn't located, but you have a reasonable explanation for that. I can see if you didn't have that. I can see if the crime scene was not contaminated. I can see when law enforcement arrived, the passenger side door wasn't open, wide open. I can understand it if Miss Tara Walker's brother did not arrive at 2 a.m. before law enforcement did. Or at around the time of, had to be before, because he wasn't documented. Was he invited over? Who invited him?
Tara Walker.
Sounds like an ambush. Seems like an ambush. That's a reasonable inference that can be made. Nonetheless, Mr. Dority reasonably believed that Mr. Payne had a firearm on his person. And there is a strong inference that there was. Either Tara's brother left with the gun, or Tara left with the gun, or the gun was left in her car, or her father took the gun. The crime scene was contaminated before law enforcement arrived there. Tara's testimony should be taken with a grain of salt at best. She didn't even want to acknowledge the fact that Mr. Payne arrived on scene before she did. Vacillating between that.
No, she
Evasive.
admitted that.
You remember when I asked her on cross-examination? Before Mr. Lawrence Dority walked away and went into his home, he actually asked Mr. Payne, why are you here? Right? Tara Walker says, I can't recall if he said that. Can't recall. How convenient for you not to be able to recall that fact, but you can remember everything else, like the selective amnesia, when a fact is not a fact in your favor. Come on. Reasonable doubt. Come on. How's this justice? How's this fair? Where's the integrity of this prosecution? Remember, the state had the burden to overcome. Remember that. There is so much wrong with this. The integrity of this prosecution cannot be established beyond a reasonable doubt. The state tried to impeach Mr. Dority about what he said to police, but they failed to show you the interrogation video.
Objection. Halliburton equally available for defense.
Sustained.
The burden is not on us. You hear that? The state want us to provide you with evidence when it's their job to do that. You got to hold that against them. Throwing rocks at a glass window, hide your hands.
Judge can approach.
Yep.
So he did it because he had a gun. No one ever saw that gun. The defendant didn't say he had a gun. But the victim's girlfriend, who stayed at the scene till 7 in the morning, or her brother, took the gun. But he never tried to elicit that fact from her when she was on the stand. But you can all make the assumption that there was a gun at the scene that he was threatened with, even though the defendant never said anything about any such gun. Talking about throwing jello at the wall.
Remember, it's their burden, ladies and gentlemen. Literally, this is a homicide investigation. What kind of investigation was this? This case is literally about who do you believe at this point. It's literally Lawrence Dority versus Tara Walker. No other witness brought any value to this case, ladies and gentlemen. Crime scene investigator didn't collect evidence. She admitted that to you. Maybe due to relatively inexperienced tenure of being a crime scene investigator, but it's not to talk bad about her. She's very educated, obviously. But the state has utterly failed to prove that Mr. Dority did not act in self-defense. This appears to be some sort of rush to judgment here. You know, some sense, that's what this was. Ladies and gentlemen, Mr. Dority has exercised his constitutional right to a jury trial. And we truly believe you will make the right decision here today. Justice requires a finding of not guilty. He acted in self-defense of himself, his son, his father, given the darkness of the night, 1:30 in the morning, the size difference. He cooperated with law enforcement. Why was Mr. Payne there? Why was Tara Walker even there? This was a setup. Why didn't they leave?
I wouldn't, because I haven't had enough threat that I think it's justified.
Mr. Dority was not intoxicated. There's no evidence of this. Mr. Dority's father drove him home because Mr. Dority's vehicle was in his own driveway. How else would he get home? Walk with his minor son at 1:30 in the morning? We're not challenging whether the firearm was functional or not. So FDLE testimony from Ms. Kristen Killinger, not an issue. Mr. Dority testified at 1:30 in the morning. He, his father, and his son was on the way home. As they arrived home, Lawrence sees a car parked in the corner of his home, and he automatically assumed it was Tara. So he thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. So Lawrence walks over to greet her to say, hey, or inquire, why are you parked here? Mr. Payne gets out the car, and when he gets out, he's looking down at Lawrence. He has his hand in his waistband. Lawrence could see something silver sticking out on the side of his hip with his hand on it. And Lawrence asks him, what are you doing here? Mr. Payne replies, this is the words from my notes. He actually said, I'm not playing with you, I'll smoke you. That's what he said. I'm not playing with you, I'll smoke you. Lawrence replied by saying, what? Threw his hands up in the air, started freaking out. Lawrence's dad rolls down the window and asks, is everything okay? Lawrence replied, I don't know. He goes into the home, retrieves his firearm so he could safely get his son in the house. So he returns outside and sees Mr. Payne has moved his car up even closer, and he's gotten back out of the car again. At this point, what do you do? It's dark. You have no duty to retreat, first of all. If it's troubling you that he didn't remain in the house and go hide in the closet and get on the cell phone and call the police, he's not required to do that. He's protecting his castle. He's protecting his son. He's worried about his father. Why are you here? Can you please leave? Mr. Dority is 5'8", 145 pounds, had no relationship or affiliation with Payne. Lawrence did not invite Payne over. Out of all the 15 years he known Tara, he had only met that man maybe twice. One time at some girlfriend's mother Thanksgiving or something like that, he showed up unannounced. He couldn't even recall the other time he met him. Lawrence went back in his house because he felt like his life was threatened. The jury instructions, the law in the state of Florida supports self-defense in this case. This is one for the books. You have the ability to send a message.
Objection, improper, asking of the jury to send a message.
Sustained.
Ladies and gentlemen, we trust you will render justice and make the best decision, one that is fair, one that justice requires. Lawrence was just trying to go home. Lawrence didn't know Mr. Payne's mental state or his motives. You know what was going on.
Counsel, your 45 minutes that you imposed on yourself is up. You need to wrap it up. You started at 9:55. It's 10:40.
Thank you, Your Honor. Ladies and gentlemen, we trusted you would do your job today and find Mr. Dority not guilty, because that's what justice requires. There was no rebuttable evidence. Not guilty. Thank you.
State wish to give its rebuttal?
Yes, Your Honor.
Everything that man just said. Oh, he's gonna play the ring camera again. Boom, 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 boom. I hope this is taken from his time as well.
I don't need the lights off just yet. I gotta get the, shut up.
Oh.
Thanks.
No, that's not a good advertising for his defense. He didn't seem like he kind of understood the case.
So one of the first things that opposing counsel said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. And the facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, you're not guilty. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence
He was 5'8", I think.
is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case. And opposing counsel talked about a peanut butter and jelly sandwich, right? So have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second
No, the defendant is 5'8".
degree murder.
Didn't she say that? Oh, the victim. Sorry. Yeah, she was 6'8". Sue, stop yelling.
And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you didn't see the actual text message that Tara Walker, talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe with no evidence that the gun was present and was taken, But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened with this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim, and yes, the victim was tall. He was 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him are engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adreian Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adreian Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father. He wasn't protecting them from some sort of threat from the victim in this case. This is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Tara Walker say, "Why am I here?" It's not like, "Why am I here?" Like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there, and she's asking, "Why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that?" And there's one reason that she was the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle, and why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, "Did you say that in your interview with law enforcement?" "Well, I don't know. It'd been a while." This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not in arm's reach of him, not on his property, not armed, is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So Opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So he's guilty. Now I'm going to play for you the clip that shows the audio and then Tara Walker running afterwards.
Triple H's first wrestling name was Tara Rayner. Or was it The Undertaker?
And you can hear for yourself. You can't see it, but the audio paints a picture.
See, Jemima, Sue is even yelling at you now. Let's paint the picture.
Don't put your gun out. You're asked to come here. Pleading with you. Do not pull your gun out. Do not pull your gun out. You were asked to come here, Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adreian, put your gun away. Adreian, don't pull your gun out. Adreian, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
So, both sides have closed, and now to the final poll. Not what you would think and what you would vote, but
All right,
what
ladies
you
and
think
gentlemen,
the jury
we'll
will find.
resume with the remainder of the jury's instructions beginning on page 13. Starting with rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm, okay? Each of them has a caption. That's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Alexander Dority. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in the 9th Circuit here in Orange County. The verdict form gives you 3 options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of the lesser included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do 3 things on the verdict form for me. You need to check one of the 3 options: guilty of second-degree murder, guilty of manslaughter, or not guilty. One of those 3. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form. Okay. You'll need to make sure that you do all 3 of those things. Otherwise, the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now. Okay, so just make sure we get those 3 things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are 4 of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then must answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number 1 is only required if there's a manslaughter, or if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder. And it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's 2 options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those 2 options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have 2 options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. As you did with the other ones, you would select one of those 2 options, date it, and sign it. And then the last 4th special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those 2 charges or those 2 counts, that count or the lesser included, then you would have to do this finding. And it says, if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The 2 options are, we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those two options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you've reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The forepersons should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic
Only
devices
seen
into the
Massachusetts
jury room.
pick the
The
foreperson.
deputies, cut off. The deputies will collect them before you go
And-
in. They'll give them back to you when you get out.
No, did they do it? In the
If you
Valley
need to
case as well?
communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I'm going to talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of these exhibits will be sent to you with you into the jury room when you begin to deliberate. The exceptions to that are, obviously, we're not sending a firearm back into the jury room. If you would like to see the firearm, write me a note saying that you'd like to
Thank
do that.
you. Cheryl
We'll bring
with
you
a
back
great
in
yes.
and we can show you the firearm.
It
okay?
helps the algorithm.
The other exceptions, do you have a device that is approved
I do.
to go back into the jury room? Have you confirmed it?
Yeah, but
Assuming the parties
I
are in
just don't
agreement,
get it.
then we
But
can
again,
send
we
back a
don't use
computer that doesn't
forepersons
have
in Denmark.
access to the internet or anything to allow you to do research. It'll simply allow you to play the videos that have been placed into evidence. If that's the case, then I can send those back into the jury room with you. So I just need to know from you all.
Good. The laptop does need to be plugged in to work. It's an older laptop.
But it doesn't have a battery either, so you got to old school plug it in the wall. Okay. All right. Any objections? All right. So all the other evidence will go back with you so that you can take your time, use the computer that's provided to review the exhibits that require the use of the computer. The only exception is I'm going to leave the firearm in here. If you want to see it, let me know by sending me a note. Okay. All right. In closing, let me remind you that it is important that you are to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the jury instructions as read by the state?
Not from the state, Your Honor.
Defense? All right. We had 2 of you that were selected as alternates. So if those 2 of you would remain seated, the remaining 6 of you can go back and deliberate your verdict at this point.
Why did you turn the audio off? What happened to the audio?
And badge number 621. All right, the 2 of you were our alternates. We select alternates in the event somebody gets sick. Everybody else is healthy, so this will conclude your all's jury service. If you 2 will just remain seated there, I'll give you some further instructions. The remaining 6 of you at this time may take your notes in the jury instructions and head back to the jury room to deliberate. And they've already gotten their orders. Okay, thank you. All right.
All right.
Go ahead and hand them these. All right, go ahead and have a seat. All right, gentlemen, you all were selected, as I indicated, as the alternates in the case. Whenever we have a case that's going to go more than a day or two, we will select alternates because life happens, things happen. Had somebody had an illness, a family emergency or something, and they had to be replaced, one of the two of you would have been asked to step in. Fortunately, it looks like the remaining 6 jurors are all healthy, and so they will be doing the deliberations in the case. I know that jury service is an inconvenience. I know that it is an imposition on your time, but it is a very important part of our system of justice and a very important part of American citizenship. And for giving of your time the last 2 or 3 days, I do wish to sincerely thank you. You will not be called for jury service for at least another year, if that's any solace for you. But with that said, this will conclude your jury service. Do either of the two of you need an excuse for the last 3 days? Okay, if you could generate one, I'll have the clerk generate that. You already got it? Yep, all right, so she's already generated it for you. With that said, with my sincere thanks, you are excused from jury service at this time. Okay.
Mr. Court Officer, you need a bigger utility belt. Florida has 6 people
Have
on the
both the
jury.
state and defense agreed to all the evidence the deputy's taken back?
State's in agreement.
Okay. All right, go ahead and have a seat. All right, Mr. Dority, you have been present for the entire trial, correct? Yes, sir. All right. And you've had an opportunity to provide your input to your attorney at all the important stages and the various stages of this trial? All right. And I know we've talked about them, but we've talked about the witnesses that were called. We talked about the jurors that were picked. We talked about some of the strategy that you and your attorney have made during the course of this proceeding. Have you been satisfied with your attorney's representation of you? All right. Has he done everything that you wanted him to do? Was there anything that he didn't do that you wanted him to do? All right. So is it fair to say at this point that you're completely satisfied with his services? Okay. Anything further from the state at this point?
Nothing further from the state.
Defense? All right. We will be in recess at this point pending a question or a verdict. If you're going to leave, just ask that you give your cell phone number to the trial clerk so that we have ability to get a hold of you and that you remain within
I believe
10 or
DPs are
15 minutes
12
of the
people.
courthouse so that we can get you here, okay?
They can have split decisions.
All right, we'll be in recess.
Let's freshen up our timeline a little bit because we need this. We need some joy and some laughter in our life.
Oh crap.
What do you? Can I help you?
No.
What are you doing here?
I'm really sorry. I was going to ding dong ditch you guys. I'm super sorry.
Did your dad know you're out here doing this? I will call him right now.
Yeah, he does know.
I doubt that.
What's the holdup?
I've been caught!
Oh, run!
Is that your dad?
Yeah.
He goes ding dong ditching with you?
Yeah, he says it's a core childhood memory and he wants to be a part of it.
Run!
Okay. You gotta go. Are you kidding me? Oh my gosh.
all. I'm doing this to try and make the audio as good as possible, and then I do this. But it's important to make these memories with your kids. Make these stupid little things that they will sit one day when they get their own kids and think, I remember when dad or mom did that. And I never played Ding Dong Dash with my kids, but I think I helped them have a few fond memories. Oh, Valhalla is up. But don't do it the way that. Did you see those kids down in Florida who kicked the door in while having air guns? That's a really, really, really easy way to end up in a morgue. To try and kick a door in and shoot people with a BB gun. Because just see what happens if you're parked in the street. Well, then maybe make some other memories. Play throw water balloons, have fun, go jump in a lake, do something. It's so important that even though we are to be the people who guides them through their life, we need to have some fun memories as well. My daughter, when she was maybe like 6, we started watching wrestling together. She only did it for maybe 2 months, but we sat and we watched wrestling together. My oldest daughter hated it, but my youngest daughter got into it for like 2 months. So we sat every day, and when they were at my house, we would watch old wrestling. That was amazing for me because it was a big part of my childhood, and share that with my daughter for a couple of months. It's yeah. Oh, we both ding dong dashed and prank called a lot of people. That was fun. Nikki, hope everything will go well. We've come a long way from tossing the football around. I think a lot of the problems are that parents have forgotten their parents. They want to be friends. And at the same time, they have also gotten into that state that kids cannot get injured. They cannot have a boo-boo. They must always be driven everywhere, protected everywhere, and never have fun. As I said to my daughter when baby Baker fell out of the bed and he hit his head, said that's not going to be the last time in his life. I spent a lot of time getting stitches in the ER when I was a kid. And at the time, probably wasn't funny, but it's kind of funny when we have family get-togethers now, and we're talking about that time where my brothers wanted to teach me how to ride a tricycle. So they pushed me down the stairs on a tricycle. And maybe someone said they did it on purpose to hurt me. Oh, others say maybe my brothers weren't that smart, that it's really hard to bike down a stair. But they made up for it. So the next time they wanted to try to teach me riding on a real bicycle, they put me on top of a hill and just pushed me down the hill. I only got stitches one of the times. Got over my fear of roller coasters to be able to enjoy them with my kiddo. Got over my fear by riding almost every ride in Dollywood. Yeah, that's fun. I sadly couldn't do much of that because of my back. I can't do the bumpy bump. But we used to go in Copenhagen. There's the world's second oldest amusement park. It's called Tivoli. Yes, like the part of Rome. I know you're always thinking Tivoli in Rome. Yeah. It's named after that. It's where Disney came to get his idea for Disneyland. That was the first one, right? Disney World. But my mom, she used to give them like a year pass every year where you had admission to the park, and then you get this you can ride everything card. And we went over there like twice a year, and it's one of the things. Now we were at Legoland with Baby Baker. And we were talking about when we went over there, and that's the way they reminded themselves of my grandma. That's so nice. Yeah, if you didn't visit, I was so well known at the well, my mom worked at the lab at the hospital, so that helped, and my dad was an EMT as well. But when I came out there, we had this very I don't know what the word would be in in English, but she was a very she was a sturdy gal. Very, I remember her as very tall. She probably wasn't that tall, but I was a little kid, and she would always come over and she'll just grab my head and she'll give me a big kiss and say, "Go home and give that to your dad from me." I was like, "What?" But yeah, I remember her to this day. When I when my daughter was 5, we went to a movie. Then when it was over, I said, "Let's sneak into another one." We sat in the theater for all 5 minutes before she chickened out, so we left. Yeah, but she'll remember that how you were gangsters for that day. We actually had. I was in the subcommittee who had to deal with schools and kindergartens and stuff like that, and we had this plastic rubber thing put on when we built new playgrounds, and then 2 years later they found out, oh, we didn't really put the cover on, so it'll seep out all the bad stuff from the plastic. But hey, did it in the best way. There's so many differences in raising boys versus girls. Boys are pretty much like rubber cement. Girls are like fine china teacups. My girls have had a lot of boo-boos as well. Here's today's being National Cheesecake Day. Jizzy, you take that hatred into a Swedish channel. Cheesecake shouldn't have a holy national special day. It should have been kicked to the curb because it's not a cake. It's just settled cheese. Ugh. Not even sprinkling it with sugar would make cheesecake good. That's why I ate the Black Forest cake when I was at the Cheesecake Factory. But the White Rabbit was nice enough to make me test her OG cheesecake. It was horrible. Ugh, sour. Ugh. My brother thought it would be a great idea asking me to jump from the roof with an umbrella. He wanted to take a photo. Well, it hurted, and the lawn was ruined. But then we laughed, and when the pain was gone, yeah, it happens. Oh my! Oh my! Oh my! You and Mo are gonna do that. You're gonna look at the Coburger today, right? I don't think we have to wait a long time for the verdict, so maybe I can chuck people over there. Explain how Denmark can both insist on these rubbery playgrounds which kids don't enjoy, but also have forest kindergartens where they play with knife. It makes no sense. Well, actually, if you go to the Rasmus Klump part of Tivoli, the kids like these bouncy bounce, but kids will be kids, so they will still crawl up to something, fall out of it, and hurt themselves because that's a part of growing up. But I grew up in a forest. Well, we did have a house, but we had a forest in our backyard, and where we lived, we always played down there and built small cabins or small hideaways and stuff like that. It's fun, and kids enjoy it, and you get to use this one instead of always just putting a tablet in front of a kid and say, "Hey, let someone else be creative for you." They get to play. We once dug a hole to. Hey, we're gonna make an underground lair. We didn't tell my dad that we had dug that hole, and he had to walk down the hill we dug it on. That probably wasn't the best idea. He got a little mad when he fell into that hole. Oh, it's tonight. Oh, I thought it was at 2:00. Thank you. Cheesecake is nasty. Try to be a preschool teacher today. There's so much we can't do. Safety takes all the fun away. Yeah, and parents have gotten way too, oh, my poor little baby. babies need a few scuffs and bruises. It's part of growing up. I had a buddy of mine who is a preschool teacher as well, and they had this kid who they were like, he can't be in a normal preschool. He is out of here. And because we have the inclusion thought is very prevalent in Denmark, so we don't separate the weird kids out. We just let them be, and then they will be normal kids. So they sent a specialist out to handle him when he got his small episodes. The first day she was there, she was like, because she started knocking people around and stuff like that. So she went over and sat down and said, "Hey, I know that you might feel that you could, but you have to understand that other kids." And he just whacked her in the face. And my buddy and the other preschool teacher, they turned around and walked inside and thought, well, now she knows. Yeah, but leave the blinds open. Cheesecake is not delicious. It's sour and bleh. Talking about being bleh, I know I have some of the smartest people online watching me. You all know and love Grant Smith Ellis. And I think weed isn't legal in Denmark. And I know some of you partake in the... But can any of you explain this to me? This is his view of the overlapping concentric social circles involved in the John O'Keefe, Karen Reed, Aidan Turtleboy Carney, Lindsay Gitani, Brian Tully, and Sandra Birchmore federal probes. So he has color coordinated everything for blue, the adults in the room, future U.S. Supreme Court justices. Black and red, potential federal probe target or cooperator. So these are the snitches. And then we have the potential federal probe targets. And I'm looking at this. So, first of all, Hank Brennan, future U.S. Supreme Court justice, that's as likely as me weighing 100 pounds. I won't do that till I'm dead. And I don't know who U.S. Attorney Leah Foley is, if she's the one who took over after Judge, Judge Levy. I don't know. But these are the potential future U.S. attorneys or U.S. Supreme Court justices. Then we go over to, let's start from the left. Sandra Birchmore. John Fanning is a potential federal probe target. I think that's a good bet. Brian Tully is a target from the feds. Have we any indication of that? Michael Morrissey is a potential target, but also a potential snitch. If Morrissey is snitching to the feds as an elected DA, come on. What? Then Matthew Farwell is a potential snitch. Dustin Chow snitch. William Farwell, he's just a target. Robert Devine, he's not spilling the beans. And good old Yuri Bucky, he is not a snitch either. So the big revelation is Michael Morrissey is potentially in Grant's world working with the DA. Not DA, FBI. In a sting operation against his own workers, because Brian Tully used to work for the DA's office. Didn't Yuri Bukaki used to work for the DA's office? Does that make sense? Well, it's the same players. A lot of the same. Morrissey is, yeah. And then we have Jessica Leslie, who I don't know who is. But Judge Levy is the target of a federal probe. How? he's a former U.S. attorney. Rachel Rollins, yeah, she could be because she got outed when she apparently misused her position. Aiden Carney, who I had on the show last week, and I didn't know this at this time, but had I known, I would have asked him, is it true that you are a federal informant? I don't know what, if any. But then you have David Yannetti, Karen Reed, and AJ are all federal probe targets. So Aiden, I think we have to read it this way. Aiden is spilling the beans on Yannetti, which will then lead to Karen Reed, which will then lead to Alan Jackson, which will then lead to Dustin Chow, which will lead into the Birchmore trial and will lead to the Judge Levy, if I understand it correctly. Then, of course, we have his paramour, his future baby mama, his I'm going to lose my cherry and I'm going to lose it to an expert. Lindsay Gattani, the cray-cray who, yeah, you know, you love. In that case, the good old Sasquatch, Krusty Panties herself, is apparently a federal probe target. Marty Kraft, I think he's a PI, I'm not 100% sure, who worked with the Karen Reed team. So why is he in this one? I'm not sure. But he is also an informant. And then you have Jason Haley Boyles, who is a target, and Christy Cretone, who is a target. And then you have Nicholas Guarino, who is a snitch. And then you have Brian Tully again, but you also have Brian Tully over here. Does this make sense? And Brian Tully will snitch, will not snitch because he's not a snitch. It's Guarino that's a snitch. But he will go to Aiden Carney. Can anyone tell me what this is about? This is from Grantee. Oh, Jessica was the grand jury leaguer. Oh, yeah. Yeah, so Just Levy is going to spill the beans on her, and then she's going to spill the beans on Rachel Rollins, who was removed from office before she leaked. Correct? No, Mass, you don't understand it. The second Karen Reed trial was actually, and this is really genius, it was a setup by the feds to have that trial so people who lied on the stand could be swept up by the feds in the Fed-proof sting operation after. Grant has figured all of this out, that they had a second trial against Karen Reed because the feds needed ammunition to try and get to some of these people, potentially Morrissey, potentially Bukaki. So that's why they gave it another try. It's Grantee. Yeah. Have a great day. I don't think even pot can make you this crazy. I didn't think it could get worse, and then Baker brought out his red pen. Well, I'm trying to make it easier to understand. Have you ever watched? Sometimes I just go in to see what craziness he's on, and he's constantly flailing his arms about, talking about these JFK leaks. It's really it's amazing when you start to see that Jack Ruby actually was Jack Rubenstein. You know, then you know, and he absolutely did not die of cancer. He's still out there. He was released because he was working with the federal government to. He's absolutely crazy. Do we think Wendy dropped Grant as a baby? I think she tossed him. If Grant makes his own wheat brand, I'm buying some a lot. Yeah, we'll set up a parallel import to Denmark and make bank. No, the apple doesn't fall far from the horse, as we say. I don't even think that it's a Happy Meal with one of those. That's another thing. Who the hell are the parents who say, "Oh, I'm going to buy a Happy Meal, but I will disappoint my kids, so I'm going to buy the ones with apples instead of fries"? Come on now. Talking about being bad parents. Grandy seems to be changing his tune on Karen Reed. He seems to be absolutely lost. He is going hard after Kate Peters. And if you didn't know, Krusty have 2 appointments today, apparently, in a courtroom in... Now I have to go back because my wonderful mods, of course, found it yesterday, and I could probably just have asked Scott McGinnis. Why do I have to go so far back? And Marissa said she can't get a Zoom link. It's in Dedham District Court, and case number 2454 CR 001024. But there is no Zoom link. And she will be participating in the trial that has to do with that's wrong, but that's Catherine E. Peter, witness, juror, police, court official, intimidation. Original charge: witness, juror, police, court official, intimidation. That's a felony. Catherine E. Peter, misdemeanor, 100 days or less incarceration. Harassment prevention order violated, C258E, paragraph 9. So Krusty can really, if she gets on her bicycle and really tries, she can beat Aiden to prison. Remember when they all sat there and said, "Oh, Aiden is gonna go to prison," and now Krusty is having her second day in court to most likely get a conviction. Couldn't have happened to a better person. Well, worst person, because she's the worst. And just so you know, we are still following the court case. Who feeds their kids McDonald's? Well, don't do it every day, but it's okay sometimes if they need a little special treat. Just don't grow them on them. Who is Krusty? Well, I can tell you, I can show you. She is a wonderful, wonderful mother of 2 to 4 kids who used to work for Aiden Carney. And she goes on the Twitch by the name Masshole Mafia. And following her is a joy. It has paid my Twitter the last month because my videos on her tend to do okay. I get like $8 or $9 in ad revenue. And I can't see this because of the temporary fucking rules. But the feds never shoot and miss, Karen Reed. And I can't see that one because the stupid English rules. The DOJ has Karen and Co. in a Chinese fire drill. Delicious. She's sharing Braden Carney, who is, I can't say that he has a medical determination that he is retarded, but he reads like he's retarded. Thank God she recovered quickly enough to go live 2 days later and beg for money. Free Karen Reed is the gift that keeps on giving. Someone had an emergency and she is the woman who has been begging her supporters for money. She even made a free or Justice for John O'Keefe t-shirt that was so overpriced that even my grifting heart started to flutter a little bit and say, oh my God, can you get these EBT card carrying idiots to pay that much for a t-shirt? And I'm sitting here with a wonderful chat, and I make like $2 a t-shirt if anyone buys them. Thank you if you do. Actually, buddy, Karen Reed regards David Yannetti as out of his league. I wonder what she'll have to say about you behind your back. Optimistically, I hope she just assumed he had more morals and ethics than Jackson. But if so, he gleefully proved her wrong there. Karen Reed's new criminal defense attorney, Steve Busang of Dedham, has filed a motion demanding the Massachusetts State Police return her Lexus. Oh, this is the hottest of take. This could just be a byproduct of a clearly overtaxed DA's office run by an incompetent idiot. That's Michael Morrissey, the man she has been praising for 3 years, who is too busy violating the law by refusing victim witnesses access to an advocate. The McAlberts has no right to an advocate. They were witnesses. The case is over. It's done, though. There's no evidence they are being harassed because they haven't filed any police reports they were harassed, but they cry a lot in the media, you fat fuck. Oh, sorry. And trying to brush off his inability to take an online cult mob to task under the delusional belief he's going to get reelected. Or it could be a case of civil forfeiture, where the government would have to prove by the preponderance of the evidence that the property is connected to criminal activity. Karen Reed is, after all, a convicted criminal now. As the Free Karen Reed folk like to lob around now, and it was that Lexus SUV that she drove drunk, the phone, who knows? Besides, if she wasn't lying when she told people she had to stop making payments on it, the bank owns it anyway, making it not hers to recover. And I, of course, went in and said, hey, Krusty Panties, as a convicted criminal in Massachusetts, do you find it reasonable to believe that they would make a civil forfeiture, what is it called? A civil forfeiture on her car for a first-time misdemeanor? She didn't answer me that. And as a convicted criminal, do you think it would be fair? Because Krusty Panties has pled guilty, so she is a convicted criminal. And again, if she's not making the payment, it doesn't make it the bank's per se. It just means that she will have a shit ton more money she will have to pay when this car will be returned to the bank. She's still on the hook. It's not like she could go down and sign the deed over and said, hey, by the way, you have taken my car from me. Here are the payments. Give them to the taxpayers of Massachusetts. So this is Krusty Panties. She is the biggest asshole in Massachusetts that you will ever meet because her life consists of one thing and one thing only, and that is to hate Karen Reed because she hates Aidan Carney. She is now she believes that, and yes, there has been a lot of crappy things going on in the Free Karen Reed movement, and she wallows in that. But she forgets that in her own movement, they are all infighting. Grant is shit-talking her all the time because he thinks he's the gatekeeper to Lindsay Gattani's pants. So he really tries to hate as much as at Kate as possible. And if you don't know the full Kate Krusty the Clown's backstory, she also lost 2 of her children. Well, she gave them up for a better life because she was told you can get rid of your deadbeat boyfriend who allegedly was a little too fond of the drink or something, and you can have your kids. And she said, nah, I don't want to change my life. Get them kids out of here. And she then made her other kid call Aiden or text Aiden some of the most heinous shit I've seen online. Sorry. They need to fix that tail light they broke before they return it as well. They won't do that. They won't restore the center console or anything. They'll just give it back and say, yeah, well, we had to do the investigations. She has an OUI which is slightly more serious than a speeding ticket. Yeah, and it's the first 2 times you get a misdemeanor in Massachusetts. It's get an OUI, it's a misdemeanor in Massachusetts. She has been paying it according to her attorneys. Yeah, well, I always go to Krusty if I need facts. Yeah, you are a little behind. I wouldn't want the car and SUV back. I would want the value of said items at today's price plus interest. That's what the bad thing is. They have had. Oh, my stupid knee. They have had that car for 3 years, so it is what it is. It doesn't have many miles on it, which would it would have some value, not a lot. But then they have the busted tail light. Oh, there was someone walking in court. You have the destroyed infotainment system. You have the destroyed center console. And I will bet you, as I said in my video about it, these a-holes have used it on their own time. I'll bet you they have joyrided in it because they were like, hey, F it, she's going to go down. No one's ever going to claim this car. And you have Adam Lally, an ADA with 20 or 25 years of experience, who doesn't even read his emails from the defense attorney saying, hey, can we get our shit back? She was found not guilty. There's no reason they keep it. And actually, because a lot of people are saying, well, Karen Reed should just sue the hands off of them. She can't really do that. There's a high level of protection for the police and DAs and stuff like that. So it'll be highly unlikely that she will be able to win a significant amount of money from the state. But keeping her possessions without a sufficient legal reason to do it could actually be one of the few things that she most likely would win a lawsuit on. I know a lot of people are saying, oh, she can just sue on Bev. Nope, no reason to do that. And she has a high immunity. Well, she can sue Lally. Nope, he just acted upon what he was told by the officers. I'm not even sure she could sue Proctor because as a police officer, he has a high degree of, they keep walking around inside the courtroom. I don't know if that is meaning anything. If it was a 21 Lexus I wanted $1 it would take to buy a 2024. Yeah, I'm just not sure you can do that because the state kind of have all these. It's the same with the rules at if you have, I don't know how much it is in America. I think it's 100. No, it's not 100,000 in Denmark. If you go to the airport with more than X in cash, they will seize it. And you say, why? Well, we believe it could be linked to a potential crime. Why? Because you have a large amount of notes in your pocket. Yeah, but it's my money. Here's my bank statement. I took them out of my bank yesterday. Yeah, but what are you going to use them for? Well, I'm going to Tennessee and going to meet up with my buddy Val, and we're going to buy a kangaroo and make money on him fighting it online. Oh, they're moving the camera. I need to end the poll now. End the poll, end the poll, end the poll. What do you think the jury will find? Guilty second-degree murder, 54%. Guilty lesser, 30%. Self-defense, 9%. And 5% hung. I'm with guilty in the second-degree murder. I don't think they really proved this stuff. They moved the camera. We're keeping an eye out. No, but I didn't tell them I'm going to buy a kangaroo because my buddy Val told me he can take a kangaroo. And they'll say, yeah, well, you have $1 over the allowed amount. We're going to seize it because it's most likely criminal. No reason that you could, well, you should do it. Court TV brought up a good point about the Lexus last night. The Lexus was never admitted in as evidence, so no need to preserve the evidence. I think I have that right. So if they don't have a need to preserve it, they can just destroy the Lexus. But she still have ownership over it. So I don't think you can just destroy her property, even though it's something else. If they had found 5 keys of coke, they could take that. Well, I do actually sometimes go to Switzerland, not with large denominations of cash, but that's the same if my sister sends me money. I bought a plane ticket that she has to reimburse me or something. I will have a notice. Someone in a foreign country is trying to send you money. Do you know about this transfer? Because, oh, it's the money laundering. Yeah, sure it is. My husband's friend got pulled over with 10,000 and they seized it until he could prove that he made it on a job. Yeah, and that's you're trying to hide it from the IRS or something, or you're trying to buy drugs. And I bet you those 10,000 sometimes. Oh, we have the judge back. What the? Do we have anything? I haven't had any Krugerrands, but my cousin's father-in-law actually gave Krugerrands to his grandkids when they got confirmated. Yeah, that's but that's the preservance. Yeah, keeping the evidence. If it was a red rum weapon, it was evidence. Yeah, even though it wasn't presented in court as such, but it was actually presented in court because they saw it on their walkthrough. Oh, I thought we were going to do it on YouTube. Yeah, 10K is such a weird number. Consummated. No. Is there something on the Twitch chat? I don't see anything on the Twitch chat. Normally, Jemima will see it on the Twitch chat before I do it. But she's been lagging lately. She's taking... She's getting sloppy and old. What is confirmated? When you go to your church and you say, hey, do you believe in Christ? And you say, sure, give me the presents. So you get your baptism when you are around 3 to 6 months old. Oh yeah, you don't partake in our fun times. We do our baptism when you're 3 to 6 months old, depending on the situation. Normally it's 6 months. But then around 13, you get confirmated in Denmark. And that's just that you have to do a year of, they call it Bible study, but it's just a brush up to, so you know that God made Job, and Job went to the market and bought Ava, and they lived in a Tower of Babel. And then someone bought a fish, and there's a guy called Judas in there somewhere. And when you have shown enough understanding of the Bible, and you have been to church, back when I was there, you had to do, I think you had to do 10 Sundays in church in a year to show that you were a good Christian. And then you go up there. I had a burgundy suit. Yeah, I was that hot. And you'll go up and you'll be asked questions. Do you believe in God? Will live by this belief, blah, blah, blah. And you say, yeah. And then you go home and have a party. And that's that. And if you are not confirmed, you can't get married in the Danish church or buried, because you have to be part of the Danish taxpayer paid church to get tossed away, and they will tax your estate as well. So from the crypt to the grave, taxes lead the way. I think you call it confirmed, we call it confirmation. But I think it's different from, yeah. You have confirmation, we call it confirmation. You get confirmed at your confirmation. Wasn't it Brad Pitt who lived in the Tower of Babel? No, he was Joe Black. That was a weird movie. Do you get the 11th Sunday free? No. And my dad was the head of the church board for a local church. So I tried to do the sneaky one because I lost my grandma in that period. So I tried to get a free one because I'd been at her funeral. But he told the priest that he shouldn't allow that. Catholic do confirmation in 8th grade, 14-ish. Don't know about anyone else. Yeah, and we are Lutheran, so we do it around, I think it's 6th or 7th grade as well. And if you've been to a Danish church and how boring the service is, you would be impressed with 10 visits. My dad, because he was on the board, he had one outstanding demand when they had to hire a new priest. If his sermon lasted more than 30 minutes when they had their, they'll do like a test sermon to see if, we like this priest or we don't like him. If it went over 30 minutes, my dad wouldn't vote for him. Yeah, we call it confirmation as well. No, we don't need to go to church to pay them. We pay them through our taxes. 0.4 something percent of my income is my church tax. Yes, we have the Danish People Church. It's an offspring of the Lutheran Church. Or, well, we say we're Lutheran, but most Lutherans would probably not recognize it. In Scotland, we have confirmation, first confession. Yeah, but that's because you're Catholic, right? Or did the British Church take that to them? Well, we have to come back and confirm that we have been taught about God and we believe in him. Yeah, 0.4 something percent is going to the church. There's a lot of people who do the non-formation as well, where they just do all the things instead of going to church. And I was like, because one of my kids asked about it, said, well, you're not getting the present if you're not doing the deed, because it is something. Yeah, but everyone else, yeah. And if everyone else was jumping off a bridge, I would be laughing at them as well. I was raised Lutheran too. My great-grandpa was from Norway and great-grandpa was Irish. Oh, that must have been fun. Because your great-grandpa must have been Catholic. You went to confirmation camp for 3 weeks. Oh, we didn't do that. We just went to the church every Wednesday for about 2 lessons. And that was cool because we had a fun priest. That's actually a thing I've seen with a couple of my buddies, because it became a thing back in the 80s to not get confirmed, and they regret it and get it now when they have to get married. Why are you tiny? Because I've been to the gym today. I lost a lot of weight. Scotland has Presbyterian and also the Episcopal version. Bar Mitra. It's Hebrew. It's not a backwards language. Actually, Hebrew is still if you want to be a priest in Denmark, you have to learn Hebrew, so you can read the Bible in its original language. And I'm not sure that you have to read Greek as well, but I believe you're still being taught Hebrew in Danish priest college. I looked at it. I kind of wanted to be a priest, not because I'm specifically Christian or anything, but thought it could be a cool job. You only work Sundays. Do you have to get married in a church in Denmark? No. You can. I could actually perform a wedding when I was in the local government, because we just go down there and say, hey, I have some buddies of mine who would like to get married and they want me to do the service. Okay, you'll have to say this, and they then sign these papers. So you can have a like a civic marriage, which is just show up to where we have a place called Rådhus. That's where the city council is, or all the civil servants work. And then you'll be taken to a ceremony where it's kind of like the one in church, but just without the religion. You'll sign some papers and you'll say, hey, and then you'll go have your party. You can also get married in nature if you want that. That's becoming more and more popular. I have a couple of friends, or 4 or 5, who got married in their own backyard. Some of them, the priest will do it. Some of them, there's someone who is granted the right by the city council will come and perform the service for them. Are you confirmated at 18? Interesting. Is there a verdict or not? No, there's no verdict. I'm just yammering on, and there's nothing happening in court. Yeah, he just came back, sat down, so I was like, oh, maybe there's a question, maybe there's something. Civil ceremony, yeah. Well, it's because we like a good party and we like a good ceremony in Denmark. So that's why we do it. And you need 2 witnesses. Yeah, 2 witnesses who will confirm that you indeed married them. Normally, you'll bring your family. My sister got married in city council in Copenhagen at a civic function before, but that was because they were about to move to Switzerland, and it's also good for taxes and insurance, because if then one of them will go away, they can inherit each other instead of all the crap with it going back to the family and stuff like that. But they got the civic union, and then later they said, no, we want the church experience as well. And then they got married in a British Christian church in Rome. So one that followed the Church of England's rules. But he said, yeah, that's fine. He was a fun priest, because he said part of his instructions to them was, up until now, you could have smacks for fun, but in the eyes of God, smacks is to repopulate the world. So go home and do it a lot and have a lot of children. So it's kind of weird for a priest to say, go home and bang a lot. What are they confirming? I don't believe in God. Me neither. Oh, let's have a party. Most of my friends did it like Baker, but I had football on Sunday, so I told my mom, if I can't do the camp, I won't do it. So she paid for the camp. Poor mom. Well, I hope one day I'll take my daughters down the aisle. Not to give them away, just to give the last threatening look at the asshole who is going to be married to her. And remind her, even though the wolf has a gray in its fur, it's still biting. Yeah, but then just don't have it. We just call it a non-formation, and people show up and say, "Hey, you're a grown-up now. Here's your first beer." Back when I was a kid, I got confirmated at I was 12. Yeah, I think I was 12 years old because I I was moved up a grade in school. Um, that was the day where you officially was grown up. So that's the day when you could have. Yeah, you might have been drunk for the first time, for reals, reals. You had been drinking your dad's leftover beer and stuff like that, but that's the day when. Oh, we have audio.
All right, go back on the record. This is on State of Florida versus Lawrence Dority. Jury is out. The jury has provided a question. The question indicates, can we be provided with the time the officer, and then in parentheses, Morris, arrived to the scene, and it is signed and dated by the foreperson. Only for the record, both the state defense and Mr. Doherty are present. My notes indicate that there was some indication that that time was at 1:30. I've asked the court reporter to find that section of the testimony in the transcript for a readback. She has that prepared. My intent would be to have them call in or have them brought in, have that question and answer read to them, and send them back out.
No objection from the state.
No objection. Okay. Then let's go ahead and bring the jurors back in. All right, go ahead and have a seat. All right, ladies and gentlemen, I did receive a question from you all that indicates that you want to be provided with the time the officer, I believe that was Corporal Morris, who testified first, arrived at the scene, and it is signed and dated by the foreperson. You have to rely upon the evidence that was provided during the trial. I did have the court reporter locate that information in the transcript, and so she's going to read to you as part of a readback the question and the answer as.
Look how it can be done. They didn't ask the correct way, but this judge is smart enough to interpret what they wanted and gives it to them instead of trying to hide stuff and say, well, they have to formulate it in a different way. Bev, look and listen.
That relates to that question, okay?
Question, and did you have occasion on that day around 1:30 a.m. to respond to 2529 Secret Source Drive in Orlando? Answer, yes, I did.
All right, that's the only evidence that we have that was provided as it relates
But we
from
couldn't
Corporal
hear.
Morris that's responsive to the question, okay? All right, so you're free to go back and continue your deliberations at this time. All right, go ahead, have a seat. All right, we will be in recess again until such time as we have a question or a verdict. Again, remain within 10 to 15 minutes walk or return to the courtroom. All right, thank you all.
Well, I think I'm going to put words on screen on because it's 6 o'clock my time, and I need. Fuck! I forgot to buy something to make for dinner tonight. That was dumb. Before that, Aiden shared this the 24th. Said, last stop on the whole tour before my vacation. That was on with me. And then Tuku Benedicto Ramirez says, after this, I started following Broken Baker. Thank you. And watched his live with Walt, that's Plevin, where he interviewed Plevin's book of fiction. Watching Plevin's childish meltdown and lack of conversational self-control was comedy gold. Please never take it down. And Plevin answered it on 5 days ago, so he has me blocked. I didn't see it about or even the basic facts of the case. Plevin, you are the guy who stated it happened on a Friday when it was in fact on a Saturday. But hey, you are the guy who claimed that the Salem massacre happened because of middle-aged wine moms, because you want to compare it to the people who watch true crimes, even though it was teenagers who started the Salem witch trials. Don't you come at me with the facts. You're the one who wrote an entire chapter from Karen's point of view without ever having talked to Karen. You're the guy who describes every man kind of like you wanted to do the tippy tap with them. But I'm the one who has no facts. Yeah, tell me you're salty without saying it. Broken Baker, I mean. Arguing with idiots isn't the fun you think it is. It's actually not. Because I argued with you, Plevin, and I had told my mods back me up in chat, that I didn't want to do it. I wouldn't do the easy thing and just make fun of you because you are stupid. What does that say? I don't know. I'm dyslexic. But you are an idiot. And I got into an argument with you, and I lost my cool. And I fought hard to regain it by muting you because you're such an obnoxious C word. So it's not fun arguing with idiots. The aftermath was fun. Sitting for an hour laughing at you and seeing that video being one of the most viewed videos I've ever done. Gracias. You made me probably more ad revenue than you made on your book sales. For example, I revealed on his show for the first time that I met with Higgins. No, now you're going to go do the same you did when I talked about Brennan. And rather than jump on that on the revelation, he pretended I was making it up. I did jump on it. I said, so you have been in contact with Brian Higgins. What did you talk about? I even had a butt dial from him. Oh, yeah, sure, Kevin. Sure. So we did talk. I jumped on it because I don't believe one word coming out of your stupid mouth. Broken Baker is a clown. I am. But you missed the opportunity. You should have called me a fat grifter. Plevin, whenever I make fun of you, and you don't really have any comebacks because I clapped your cheeks, and not in the fun way. And you're still salty that you lost to a stupid foreigner who only have written 4 books when you have written 1. And I didn't go to a self-publishing house who won't give me any money till 6 months because I think some of them I sell for like $2 or $3 on somewhere. Because I just make fun of stuff. But Plevin, you got clapped the heck out of you by an idiot. You couldn't counter anything I said because you have no facts. You just wanted to yell at me and show the world that you are a big old fat ass who doesn't know what you're talking about. You jumped on the anti-Karen Reed case because there was not enough money for you to make on the Free Karen Reed movement. You came in, you saw Aiden had that cornered, and you thought, I'm just going to be the opposite of Aiden. I'm going to make some dodo out of that. Sadly, do you know why Aiden can live being an independent journalist? Because Aiden has talent. Aiden has personality. Aiden has a certain je ne sais quoi. And you have none of it. You are a sad old man sitting in a chair in his mom's attic. I feel very sorry about your disease, as I've stated many times. But having a disease doesn't give you a right to be as stupid and as obnoxious as you are. You a asshole. And instead of being an asshole, you should try and think, why does everyone hate me? Are they wrong? Or could it be me who is wrong? Yeah, I have 4 notifications now, and one of them is Harry Carr, Danny T. Yeah, all of these notifications. He is a clown. Now, after that question, I'm starting to worry a little bit. He might actually get away with it. I don't know how long after. Yeah, could they potentially have thrown the gun away? But to me, that's just well. I never trust juries. Well, I can do the extra poll now that we thought that we had an answer. How long till verdict? And I have to figure out how long we have been going. We have been on verdict watch for an hour. Streamer doesn't want to say, well, I'm 3 hours in, I can't say cunt. He did, and we talked a lot about the book and its stupidity. Yeah, I actually wanted to, yeah. I never accused him of making it up. No, I don't believe I did. I actually believe that I said, oh, interesting. But where do you know that Brian Higgins? Because I wanted to know about Brian Higgins' storied history as a private in the American Army who got deployed to Iraq, and that's where he got his interest for planning. So who told you that he did any of that? Well, I've talked to him. I don't care. There's no Zoom appearance. There's no Zoom stream available. Marissa has checked. Aiden's giggle when he talks about your show is priceless. It was one of those perfect storms where I actually tried to do to Plevin what a lot of people have tried to do to Aiden, because I think I did it in a way to try and contain him, and I think a lot of people have done it because they misunderstand what Aiden is. So I wanted to keep it very locked in and ask some very specific questions, and I even think I still have, maybe could potentially still have the Google Docs with the questions that I had planned for him. I'm not good at deleting stuff like that. Nope. Where's my Plevin notes? No, I don't have my Plevin notes. But I know I had Plevin notes where I had some very, and I've been talking with the mods about it because me and Jemima read the book together. But I wanted to keep him online, and that's what I think a lot of people have misunderstood, and why people have been kind of disappointed with the Aiden interviews is people are trying to keep Aiden on track, and you can't do that with Aiden. Aiden is he's a good interview if you let him go where he want to go. I know some just want to have the same Aiden show on every channel, and you can't expect that. I just wanted to have a conversation. And I know some people. I had one ask, why is he talking so much? I just want to hear Aiden. Aiden has his own show twice a week. You can just watch that. But Plevin, because he is so bad at being interviewed and so bad at being honest, you need to try and keep him fenced in with questions. And he didn't want to be fenced in. He just ran amok. And it made a wonderful show. But I was very frustrated because I really wanted to do the right thing to him, which was giving him a fair chance. And he just wanted to take that fair chance and piss on my face. We went over the questions too because there were so many that came up from reading the book and like where did they get it from? Yeah, it was absolute. I know some of you might have seen Andy Bev read parts of Plevin's book. It's the worst writing I have ever read. It's horrendously bad. Yes, violated RPO and witness intimidation charges. Or harassment, for instance. Sorry, HBO. Yes. Yeah, that's for Lauren, right? I think it's for Lauren. I'm pretty sure. Yeah, that's what you want to do with Aiden. And then when you can feel, okay, now he's coming off of that train track, let's jump onto a new train track. Because there's some people who are really, really easy to have on as guests. Because you just serve the ball and they will run around the court. And then at some point, the ball comes back over the net and you just send it back over. And you have to catch that. Other people, you have to be more engaged and be the one who kind of drags some answers out of them, because they could be intimidated by sitting talking to an audience or being on camera, and you have to switch it up, and you have to kind of recognize what is the person. It's the same with having Andrea Burkhardt on. You just let her talk. And then at some point you'll ask a follow-up question because she talk, she knows the game. We're all streamers and we know no dead air, keep it flowing. And when you start doing so Aiden, they call you Turtle Boy, and is that because you like turtles, or is it because you think Karen Reed might be guilty, and you are really lying about it? Because I have heard online that someone called Krusty have said that you really don't believe she's guilty, and you wore a green shirt today on the show. So where did you get your haircut? Those kind of questions will not get a lot of good answers out of them. But asking him, saying, so what's up with you? And you can get 10 minutes. You want to chat, not to ask the same question over and over. And yeah, that was the thing. Because we were kind of looking at some potential questions and where because we've seen that it had gone off the rails on some of his streams. So we kind of was sitting there saying, and I did the executive decision and said, well, I'm having these 4 outlines and I'll try and get to them. And I think I got to 3 out of 4, but none of it must be. The thing is, if you're having Bob Alessi on, yes, you want some questions because he's not a streamer, he's a lawyer, and you really want to get this out of him. But if you're having me on, you just want to try and get me going somewhere, and I'll fill the air. I'm pretty good. I've been talking for the last hour without any content, so I can do it. Most of us can do it, because that's kind of our job, is just to talk a lot. And we know the rule is don't have any dead air. So if you'll ask me a question, I will try and find an answer to it, and I'll try and make it entertaining, because if I go on your channel, that's potentially one person who will come and watch my channel. So I will try and present myself the best way possible, unless you go on a show where you don't get recognized for 3 minutes and then people treat you really bad, and then you probably just want to get out of there and don't talk about it. But a lot of people think that because Aiden is a big name, we have to be professional. No, Aiden is not professional. Aiden is a gonzo journalist. Be funny. He's funny. I like turtles. So do I.
I like turtles.
Just have them in your back pocket. You might have a lot of questions. My first panel show, I had a lot of things lined up, and I was really, but I never really got to go there because we just backed and forth. And back then, I might have been pulling up chats too much and stuff like that. But you try it and you learn from it. Well, that's why you don't do the, hey, Aiden, what do you think about Karen Reed? You just do a, hey, Aiden, how about you? How you doing? Did you see that stupid thing on Twitch? So, Rusty Panties just pled guilty. You go there because, yeah, I was getting him after 2 weeks of constant media tour to try and get him a little extra money for his defense fund. And I'm very happy that he chose to join me, especially because I was the last one and I felt we had a lot of fun. But it's also important that you know where you are in the line and what your role is, because there's a big difference if he's on with Melanie Little, who's an attorney who will ask the attorney questions, or he's on with the idiot Danish guy who will say, oh, yeah, I'm not monetized. You can just say cunt on this channel. I don't care. There's a big difference. And I think a lot of people sometimes forget who they are normally and what their audience like. And trust your guest. Let them run free. Bye, Helen. Are you coming back for the verdict? Well, I'm sorry. He posted a pic from Ben Affleck. Yeah. I think Ben Affleck, maybe it's because he have had quite a drinky poo problem that he looks haggard. Yeah, I'd like a verdict. What do you think the verdict will be? I think some of them might overthink. That's why Dave is a good example. He made that Lego interview style because it's disarming. It's disarming when you're sitting there building your Lego and you get a question. You are not in high alert mode and I must answer this 100% correctly. You're just sitting there saying, yeah, well, why I started my channel? Well, I really hope that my fame would lead to a lot of booblers in the DMs, but that's not what happened. That's why Dave started his channel, I've heard. Not confirmed. His wife will now kill me. But you need to disarm your victims. I did my channel started as a Danish political channel where I wanted to cover politics from the people on the ground level. Because when you watch the news, you'll get, hey, Kamala Harris, hey, Donald Trump, and you don't have the same system as us where we have 45 different candidates running at the same time as them. But everything in Denmark was just, hey, Lars Løkke, hey, Mette Frederiksen. So they just like your election where they just focus on the two heads. But there's so many, and I know it from when I ran my campaign, it's so hard to get just 5 seconds in the media unless you do something really stupid. So I thought, hey, I'm going to go and reach out. I had some friends back from when I was in politics and said, hey, do you want to come on? Do you want to do an interview with people who ran for national election? And if you have someone in your party, hopefully something new, something no one have ever heard about, I'll have them on. And it took a little while. And I did like 2 or 3 interviews, and then people started saying yes, and I ended up having candidates from every party except one. And I don't like that guy because he had promised me, but he never showed up and never sent. Oh, I'm sorry. But one of the first things I found out was we have to do this very, very low key because they're not used to doing this. They're not used to talking, and I have to be the leader of those. I have to ask the questions, and then because they are politicians, they are passionate people. If you just get that initial shyness out of them, you can get them to talk. I'm all about disarming people that I interview. I always do it. How did I get 0 credit for Lego? Because you built the one I wanted to build. But I think Dave was the one who invented it. And Dave is retired. Don't steal his thunder. He's not streaming anymore. Will Grant's latest theories involve alien abduction? His next theory will be that Lindsay Gaetani is now pregnant with a facehugger. Hot sauce challenge with questions. So funny. Oh yeah, but it's just to try and find that niche where you can kind of ask questions without, because the worst thing about interviews on YouTube, because you go to YouTube because you don't want to watch the mainstream media. You don't want to watch Wonder Cronkite. If you wanted, you would be watching MSNBC. So you want to have it. I have a feeling that those of you who are here and who comes here when we are doing the trial watch, you want to have either some funny people talking while you're working, or you want to engage with funny people, or just yell at Sue. And then if I just change it up because, now I'm having Valhalla on, so I have to say, Valhalla, that's an interesting name. Did you know it is heaven in Nordic mythology? Have you been in the North? No, the real North, not North America. Scandinavia. You have dreadlocks. Do you see that as cultural appropriation? If I did that interview, I would lose more viewers than I've done the last half hour. Chili Klaus just gets the celeb to eat a whole super strong chili with him, then interviews them when it kicks in. Yeah, he's been on the Hot Ones twice, I believe, Chili Klaus. That's a Danish musician who likes to eat hot stuff. He's the guy who always fondles his ears and snaps his fingers when he eats hot stuff. And we had movement in court again. But his interviews are not that long. I haven't seen him a long time, actually. Yeah, that's we are all. But goats is a big part of the Nordic mythology as well, because that's actually why you have lightning. That's the hooves of the goats when they run across the sky, dragging the Thor's wagon. Then it's the thunder comes from the sparks their hooves make when they run across the sky. And one of the big myths is how Thor comes to Midgard. That's the earth. And he stays with this peasant couple. Him and Loki they had been out fighting trolls. And then they come to this peasant family, and they are like, oh, the gods are here. And we don't have enough food, and we don't have food. And he said, that's not a problem, because I'll just kill my goats, we'll eat them, and I'll resurrect them in the morning. Just make sure you don't break any bones. And of course, Loki, because no, I don't do the American. Loke, because Loke is the trickster god. He convinces the kids of the farmer, or the kid called Chalfe, that he likes the. He asked him if he doesn't like the bone marrow, and he said, "Yeah, I do." Well, you can just, yeah, but Thor said you couldn't break it. Yeah, he says a lot of stuff, and he breaks one of the legs, and then the goat, when it gets resurrected next day, of course, has a broken leg. So to pay for that, they take Chalfe back to Asgard with them, and he will become important later because he's really fast, and he gets a pair of shoes that can run really fast, and they go on all kinds of excursions together. But that's how Thor got his human thrall, which we call slaves in the Viking ages. They were thralla, which now is a word you put into work. Shut up. Logan, your pick that was on my stream is pregnant. Well, congratulations. Who is the father? Well, funny story, because back when they tried to build the wall around Valhalla to keep the trolls out, they were looking for a builder. And then a builder came along who had this big, strong horse. And they asked him, "Hey, can you build an impenetrable wall so we will always be safe?" And he said, "Sure thing." And then they said, "Well, what do you want for it?" And he, I need to, I can't remember which god it was. Locust burn. Now I have to. It's too long since I. Sleipner, that's his horse. Yeah, he had this horse called Sveldifar, and that was the horse that was dragging the stones to build a wall. And if he finished that wall within a year, he would get the sun, the moon, and he would get the goddess Freya, who is the goddess of love and strife. And when they got nearer to that 1 year date, they said, "Oh, we don't want to lose the moon and the sun and Freya, because Freya is the most beautiful goddess. So how can we get out of our deal?" So Loke changed into a mare, a female horse, ran out and seduced that horse that helped build the wall, and they ran off for a couple of days, so he never got to finish the wall. And then when he came back, he wanted to fight them, and Thor, of course, killed him. So he never got paid, and that's why the wall around Valhalla will never be finished. So when Ragnarok finally gets here, Valhalla won't be safe, and Ragnarok will happen. Thor will be killed by the Midgard worm. No, yeah, by the poison from the Midgard worm. And he will kill the. I need to read. I should do Nordic myth on a budget. So Loki ended up being pregnant and bearing a horse with 8 legs. That was the horse that Odin rode on, because it was as fast on the ground as it was on the sky. Man Bear Pig is an American legend. Yeah, but it's not a lot of people are interested in Nordic myths. Ah, they're fun, but it's not really. I'm just like, should I put on words on screen, because I can see people moving around in there. They've been on Verdict Watch for an hour and a half. I need some food. I have to see if I have anything. So Loki is a man that gives birth. Yes. Don't think about it. It's mythology, but he totally is. He also has 3 other children. One is Hel. Hel is the lady who runs Hell. Isn't that fun? That's why you call it Hell in English, because she is the guardian of the hell in the Nordic mythology, which is called, what the hell? I should remember. I need to read a book. No, they call it hell as well, the underworld. She has a boat made out of the nails of dead people. Yeah, sounds nice. And she has a doorstep that'll always make you trip over it. It'll go up. And she has a bowl. The more you eat of it, the more hungry you get. That's horrible. But she's a female who looks kind of bad. Not like that one in the Thor movies from Disney. Then he has a snake, or a worm, as we will call them. That's the Midgard worm. That's so big, it's out in the ocean, and it encompasses the entire earth and bites itself in the tail. And then he has a wolf as a kid as well, which is the wolf that bit off the arm of our warrior god, who is called Tyr. A lot of people think that Thor is the god of war, but he's not. The god of war is actually Tyr. Thor is the god of aggression and just senseless violence, where Tyr is the god of war. But he has only got one arm, because when they tied up that wolf, he had to put his arm in its mouth to make it believe that they didn't want to tie him up. So when they tied him up, he bit off his arm. So we have a one-armed war god. Raise your hands if you're paying someone to play with your balls today. Yeah, I can't get it for free anymore. So sadly, I have no food and I have no Ballos ticklers. Well, I hope it'll give you some answers, even if it doesn't give you joy, Brandon. But you have to snap out of it, start getting better. We need to find out what part of the body that we need to hit in the gym if on Wednesdays we do legs, because if you want a man in a scrub rubbing your balls, you better be effing swole. I'm not as good at it as you are, Brandon. So weird question, but do you think Thor from Marvel Comics is more popular in Denmark than he is elsewhere? We don't really like the one, because Thor in the Nordic mythology is a red-headed short guy. And he's not a dainty Australian long blonde hair. He's short, he has red hair, he has a red beard, and he's not muscular. He's strong. So he's a little fat one. Let's see how we depict him. So I don't think there's a lot of people out here in our part of the world who believes he looks a lot like that one. This is from the children comics or the children movie. This is how they depicted Thor. A Loke in the background, Thor, Chalford, Røskvad, and Quark. But he would be dressed like a normal peasant with his hammer and his strength belt. He's missing his gloves because when he's throwing his hammer, he has gloves on that makes him stronger as well. This belt also makes him stronger. But this is how most of us have grown up depicting, because this was really popular cartoon back when I was a kid. Huh. Well, it's not quite like the Ouroboros because it's not a symbol of eternity. It is a symbol of the world will end. Yeah, but I thought that they might come back. I think Spider-Man is the most popular in Norway. I would guess that's the only cartoon I see around in paper form these days are Spider-Man. Hey, money. Yeah, that's how they were dressed back then. See, they keep every time I'm thinking I'll go on Word on Stream. They keep touching it. This is how he was depicted in the Viking ages. This is a bronze sculpture of Thor. So he had a funny little hat on. Not a lot like that hunky Aussie. Me, Danny, and Jen want crack. Well, I can do that, but I need someone to please be nice enough to tell me if we get a verdict, because then I'll go and try and find out if I have any food in my freezer or I need to go buy some food. I'll put on word crack just for you, Sue, because I'm such a good person. You should learn from my lessons in life. I need to take that off. Is it working today? It's working. Everyone, we are on verdict watch. We are waiting for them to come back. I hope we'll get a notice before we get a verdict, but we will cover the verdict. I'll go make myself some dinner because it's 6:45 at night, my time. If you want to hang out and play, you have to be on YouTube, or else you can scan the QR code. And apparently that's a little hack. If you want to beat Sue in the game and you are on the app, it'll help you find the questions. No, it'll help you spell the right words.
Parties are present. Mr. Doherty's present. I've been advised that the jury has reached a verdict.
What the hell? Well, F you, Sue. Ha, 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 ha. We have a verdict. Now I have. Can someone go on the Discord and share it, please? One of the mods, and I'll go on the Twitch thread and share it, so people can come back and get the verdict. I have to take the banner off. Boop, boop.
All right, go ahead and have a seat. State recognize the presence of the jury.
Yes, Your Honor.
Defense recognize the presence of the jury.
Yes, Your Honor.
All right, has the jury reached a unanimous verdict? All right, if you'll go ahead and hand the verdict forms to the court deputy for me. All right, the verdict forms are in order. Madam Clerk, if you'll go ahead and please read the verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, the state of Florida versus Lawrence Dority, case number 2022, CF 5250. Verdict as to count one. We, the jury, find the defendant guilty of second-degree murder as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 30th day of July. Person. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, actually possess a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, discharge a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding, if you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, due to the discharge of a firearm, cause the death to Adreian Payne. Special finding, if you found the defendant guilty of second-degree murder or manslaughter, lesser included crime, you must then answer the following question. We, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson.
Either party wish to have the jury polled?
The state does not.
Defense does, Your Honor.
Madam Clerk, if you'll poll the jurors for me, please.
Juror number 902, is this your true and accurate verdict? Is this your true and accurate verdict? Juror number 558, is this your true and accurate verdict? Juror number 206, is this your true and accurate verdict? Juror number 4217, is this your true and accurate verdict?
Yes.
Juror number 484, is this your true and accurate verdict?
Yes.
Juror number 693, is this your true and accurate verdict? Thank you.
All right, ladies and gentlemen, I have one final instruction for you, and that is your instruction upon discharge. I do wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that you enjoy as jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their own private affairs as long as they wish it. Therefore, the law gives each of you a unique privilege not to speak about your jury's work. Although you are at liberty to speak with anyone, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who may seek to find fault with you, and it'll be up to each one of you individually to decide whether you wish to discuss your jury work with anyone or not, okay? I know that it's been a couple of days and it's been an inconvenience to you to come over here and give of your time, but it is very important to our system of justice and very important part of being an American citizen that we have jurors like you come in and decide these cases for us. For your time here the last 3 days, I do thank you for the efforts that you have put in and the work that you have done. If any of you all need an excuse for work, we will generate that for you that indicates that you have been here for the last 3 days. With that said, that will conclude your jury service in this case. With our sincere thanks, you should not get another summons for at least 1 year from today's date, okay? All right, thank you. All right, Spencer. All right, have a seat.
Say the floor word.
All right, is there any legal reason why we can't proceed to sentencing at this point?
Are we getting sentencing?
Your Honor, I don't know if the defense is asking for a PSI or asking for sentencing.
Is he entitled to a pre-sentence investigation?
He's not a convicted felon.
He has a prior dealing in stolen property that he's on probation for?
I'm not sure if he's adjudicated guilty on that.
I looked at it, he was a withhold adjudication.
I understand it was a plea of no contest and it was a withhold of adjudication. Have you all reviewed Florida statutes 921.231?
Not recently, Your Honor. Let's do that now.
So they didn't know that he can get an instant sentence because he's out on probation for his dealing in stolen goods. That's shoddy work again, Mr. Prosecutor.
Nine 21.31 subsection 1 with respect to pre-sentence investigation reports says that any circuit court of the state, when the defendant in a criminal case has been found guilty or has entered a plea of nolo contendere or guilty, so a nolo plea previously would count as a conviction, may refer the case to a Department of Corrections for a pre-sentence investigation. So a nolo plea previously doesn't entitle him to a pre-sentence investigation. The state objection to their request?
I don't have an objection, Your Honor. It's in your discretion.
And the defense is requesting one?
Yes, Your Honor.
What I'll do is I'll go ahead and request the PSI so I can get some additional information. How much time do they normally take for those? 30 days? All right, I'll go ahead and order a PSI at this point. We'll set sentencing for August 29th, which is a Friday at 11 a.m. In the meantime, Mr. Dority will be remanded to the custody of the Orange County Sheriff's Office pending sentencing. Further from the state?
Nothing further from the state.
Defense?
No, Your Honor. Thank you, sir.
All right, we'll be in recess.
Thank you, Sue. You just needed to threaten me with word on screen and some dinner, and we got a sentence. Guilty, second-degree murder. Probably some of the worst lawyering on both sides I have ever seen. I am very disappointed in both sides as lawyers. Do I think it's right? As I see it, yes. I don't think there was enough to sustain that he was in fear of his or others' life when he discharged his firearm. So I think they got it right this time. But I can totally understand some of you might not see it the same way. That's a-okay. But there's no discussion that he did it because it's a self-defense case. So he claimed, yes, I did it, but I did it because of reasons. So he did do it. They don't have to prove he did it. I know we've had during the last 2 days, well, they didn't prove that he even shot the gun. No, because they stipulated to that because it's a self-defense case. And with a self-defense case, you don't have to prove he did it because he admitted to doing it. So that's pretty open shot, that part of the case. But I think a competent defense lawyer could have poked holes in that poor presentation from the state. Them coming in and just saying, well, this is the gun, and yeah, this lady, calling the dad, calling the girlfriend. Of course, you never know what they're going to say on the stand, but I would think a competent defense lawyer could at least have chipped something off. But the opening statements were so promising for this defense attorney, and then he just went all to hell after that. I don't know what he was trying to do, but it didn't work. I didn't think it worked. And pouring sugar on your Thanksgiving meal was the most notable part of his closing arguments. And you all know this. I'm not a fan of opening or closing arguments. I don't believe that the lawyers sweet-talking the jury should have any influence. It should all be proven by the testimony or the evidence. But I know that's the American system, so I will, of course, abide by that. But I don't think he was a good attorney. I think the prosecutor was horrible as well. But you are in there and you have to say, well, he did it because he was so scared of his life. And you have him admitting on the stand that, yeah, well, he didn't really threaten me. And then you start talking about how he potentially did the gangster tilt when he pew-pewed, but there was no testimony elicited about it. And you got struck down twice in your closing arguments because you just made up stuff. One thing is bad criminals, but another thing is subpar defense attorneys. I have to say that. 90 minutes, we've seen that in a few cases. Yeah, the problem was none of the sides really tried to tell us a story. The state was just, yeah, he admitted it because he pled guilty to self-defense. And the other side was just, well, someone else could have taken the gun that might have been there. But he didn't even say himself that he saw a gun at the scene. Yeah. This was most likely what a lot of trials are like in reality. They don't take 4 to 6 weeks or even longer They are 2-3 day cases. In this case, I would have spent a half a day more from the prosecution and tried to build a story. Maybe I would have called his dad and have him testify about, did you see a gun? I think I would have called the dad. The girlfriend, I'm not sure, but I would have called the dad and said, did you see a gun? Did you hear someone mention a gun? Did you hear him say, I'm going to smoke you? I would have done that as a prosecution, because then it would have been a slam dunk. I don't, yeah. And no, it's not because he's a public defender. This is a paid attorney who apparently has been practicing for 13 years. As with my channel, not everything gets better with experience. So I was just, I don't know. Yes, my lovely shirt from FD Food Fairy. Yes, Slidey Pie, you did miss the verdict. The verdict, well, we can go back and watch it. I just have to turn on my screen again. And let's do the verdict. If I can find it.
All right, go ahead and have a seat. State recognize the presence of the jury.
Yes, Your Honor.
Defense recognize the presence of the jury.
Yes, Your Honor.
All right, has the jury reached a unanimous verdict?
Yes.
All right, if you'll go ahead and hand the verdict forms to the court deputy for me.
For Orange County.
Forms are in order. Madam Clerk, if you'll go ahead and please read the verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, the state of Florida versus Lawrence Dority, case number 2022 CF 5250. Verdict as to count one. We, the jury, find the defendant guilty of second-degree murder as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 30th day of July. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, actually possess a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, discharge a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding, if you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, due to the discharge of a firearm, cause the death to Adreian Payne. Special finding, if you found a defendant guilty of second-degree murder or manslaughter, lesser included crime, you must then answer the following question. We, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. So say we all this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the business.
Either party wish to have the jury polled?
The state does not.
Defense does, Your Honor.
Madam Clerk, if you'll poll the jurors for me, please.
Jury number 902.
So that was the verdict in this crazy case that Jemima found for us. Interesting to see a different type of case. A lot of you might have started watching true crime with a way more polished case like the Karen Reed case. And this is also cases. We will now either be returning to our previous rewatch segments, or Jemima will try and find a new case, or one of you can do it if you join the Discord and go into the, hey, look at this. I can't remember what it's called. There's a subcategory where you can notify me if you see interesting cases coming up. Please don't tell me to watch a case from 1982 that's taped on a potato because you thought it was really, really interesting. It might have been, but it's hard enough to have to go and boost the audio on this shit. And cases from 1982 that everyone knows about isn't that great content. But please do tell us on Discord what you would like us to keep an eye out for. There's a lot of people saying, hey, are you going to cover this? Yeah, that's going to be in January next year. So it'll be there when it comes up. I think right now everyone is looking for the next thing because we were waiting for Koberger to be the next big thing, and I was waiting for not doing the Koberger. But so right now everyone is kind of in a limbo and trying to find something to cover. But we'll find something, or we will cover something else. Or I will be giving dance lessons for an hour a day where you can chuck your $1 bills at me because a grifter's gonna grift. Other than that, don't get into fights over other people's crimes. If you think he's not guilty, I'll accept that. And if I think he is guilty, please accept that as well. Doesn't make you a better or worse person, and doesn't make me a better or worse person. It just means that we have a different experience with the evidence presented in court. And don't get angry at each other just because you see cases differently. The only one who is allowed to get angry is Sue, because Sue is kind of like the Hulk. She's constantly angry. The rest of you are lovely people except Zach. And please join us again when we find something new or something old to cover. Because we are ending at 7 o'clock today, I will try and get to bed, and there will most likely be a Baker at night tonight. I will try and get out of bed so I can do it at 11 or 12 or thereabout, where we can do a little more loosey-goosey show. Please do all the things, blah, blah, blah. Go check out my videos. I have quite a few. And if you need something to do, go rewatch the Plevin live interview and laugh your ass off, because that idiot deserves it. The rest of you deserves all my love. All my love I would give you if you want.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right, 100.
100.
Because it is 100%
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.